today. Since my lord, a medical matter, my lord, I was enlisted as a OBC NCL candidate, my lord. But surprisingly, by misleading the honorable
Which bench?
bench 2, my lord.
Motion matter.
Motion matter.
Have you filed? What
Yes.
is the urgency?
Sorry.
What is the urgency?
Urgency, my lord, now already in my place, they have given one candidate, my lord. Since my name was enlisted for Kokrajhar Medical College, but surprisingly, on the basis of honorable court's orders, they are saying court's order, but court's order is not there, my lord. That is specific order is not there. She has changed from category from general to OBC, my lord, at the last stage. And in my place, she has been accommodated, my lord, by the DME, my lord. The Honorable Delhi High Court also in this case, my lord, already it has been specifically said that it cannot be changed up, at the last stage. And
When was it before 30th of September?
my lord, last admission was given 30th of September.
Yes,
I went there, but because of the changing, my lord, I could not get admission. Now, my lord, this is totally arbitrary and illegally, my lord. That
Can we pass an interim order here?
Lordship, today, my lord, at least Lordship will protect this candidate, my lord. Otherwise,
Difficult. Let us bring
Lordship.
It's a listing of a writ petition, your lordship, on the Friday, your lordship. There's urgency, your lordship.
what is the urgency?
Your lordship, that the petitioner is made the petitioner is married the boy who's of different religion, your lord. And for such, your lordship, they have eloped and they are residing at the respondent's house. Your lord.
What is the matter? What is the urgency?
Your lordship, for a shifting of the examination center from Guwahati to that Miss where she is residing at place, your lord, because there is some problem with the family members of the petitioner, your lord.
Press matter.
Yes, your lordship. Because last listed on
When the new motion matter?
yes, your lord, it was not listed because your lord, it was not reached on the day when it came up, your lord, on 29th.
And have it tomorrow?
Tomorrow, your lord.
May it please the Lordship, I am praying for listing of one writ petition tomorrow, my lord.
What case?
Motion stay.
Motion. Bench 2 matter. No, we are having 2 today. Tomorrow we do not know what matter. You have to mention before the appropriate bench. Item 5, 2014 matter, no 19 matter. Mark. Non-MPS petitioner. Who is for the response? Who's appearing? Is anybody present for the respondents? None appears for the parties on call. Sarah, you did to the list of the item 6. Item 6. B. Chetri, K. Parashar. None appears for the petitioner on call. Whereas Senate counsel for the respondents are present. Sarah, in the interest of justice, list of the
May I please, Your Lordship?
Yes.
My Lord, although my Lord, matter has been listed, my order, my Lord, file has been misplaced, my Lord, sample, my Lord. Only I accommodate, file has been misplaced, my Lord. I accommodate for today only, my Lord.
Why did you mention the matter?
My Lord, earlier mentioned, my Lord, yesterday could not test out, my Lord. Only for today, my Lord, please, Monday, my Lord.
You don't have the file. Why do you mention the matter?
Mentioned earlier, my Lord. On Monday, my Lord. I reconstruct the compassionate department matter. Instruction was also sought from.
You mentioned this on 26 September.
Right.
On 26 September, did you mention without the file?
Friday case number. On Monday, my Lord.
Though this matter has been listed at the instance of the petitioner who had filed a mention memo, comma, adjournment has been sought. Full stop. The entire objective of granting an out of turn listing appears does not appear to be there in this case. Full stop. List of the vacation. Eight to 11. Eight to 11. None appears for petitioners on call. However, for the respondents,
Lordship, I am for the higher education.
however, the
I'm junior for J. Roy.
is it there in 8 to 11?
He's on his way.
Item number 8 to 11.
Yeah. Kindly,
Which matter is there? His name is not there.
he's on his way.
Which matter is there? His name is not there in the corpus. Are you sure in 8 to 11
Yeah,
is
yeah.
name of the petitioner? In 8 is for the respondent. Madam,
Yeah.
you are for the respondent.
Please, Satyendra Narayan.
No, no.
You are for the respondent.
Oh, sorry, Anupam.
You are for the response.
Where is counsel for the
We
respondent?
car will appear with
They are for the respondent.
from this side. Then you have to respond.
List of the top of it. So the motion to prohibit. Motion.
I am appearing for the attempt 60 here, my lord. My lord. Already pension paper has already been forwarded to the director of pension, my lord.
My lord, Youngest Counsel M. Hussain is listing another report. Therefore, for the timing, it will be adjourned.
This matter is pending since the year 2022 at the motion stage. Will issue notice? Will issue notice, Sharma?
Yeah, my lord, it is a contempt matter. Yes,
That is, it will issue notice.
yes, ma'am.
Is Dr. Vijay Chaudhary still there?
Vijay Chaudhary,
Yes, Mr. Counsel, Vijay Chaudhary is not there. And the other,
Naran Kaur.
Mamta Hujra is there or not? Bhavesh Deka, Director Pension,
Director pension
Bhavesh Deka,
item.
K.S. Gopinath Narayan, A.G. Samiran Bora, Syed Muflehul Jaman.
So far as
Madam,
the
he is
secretary Vijay Chaudhary, but in her place, Narayan Ford has joined.
My lord, he is mistaken. Actually, his matter is not this line. So,
Item number 2, I thought that
We are having item number 2.
Parul Choria, Committee Committee, to some,
third move, full move.
it's not.
Kunti ko find.
Contempt petition 633.
এখন ফটো 2 তাতে 13 নম্বর ফটো
13 নম্বর ধরে।
this the list which your lordship was about to take, which is taken by court number 13, but perhaps is item number 2 of that.
No, we are taking this court matter.
Yes.
We are having bench 2.
He has mistaken.
Item number 8 to 11, my lord. So there is another notice, my lord. We are waiting there, and Lanet Senior and guest counsel, my lord. So that's also waiting there, my lord. In court number, my lord. My lord, my
What
lord, justice
notice?
to me to take it.
What notice?
One another notice published. my lord.
Arulej.
That is why I'm confused, my lord. We all. So nani page instead of nani page, you'll
भूल लिखित मोट पेले लिस्ट नाही ना भूल এটা কি লিখে বলে ম্যাটার পার্টি সিকোয়েন্স অফ স্টুডেন্টস ওখানে এসে মোট পেলে এখন লিস্ট মোট পেলে লিস্ট নাই আছে
and
ফাইল আসছে নেই না বুঝি তো বেঞ্চ কোনো যেটা ঠিক আছে ম্যাটার আমারটা লিস্ট হয়ে ম্যাটার্স পার্টিনেন্ট টু সিঙ্গল বেঞ্চ আর উইল বি টেকেন আপ as if movement মোট পেলে না সেটা মানে Are you ready with this matter?
no, not today, my lord. He Lanet other side is also Lanet Senior Counsel is waiting there to take time at the limit. So my name may be there, and my lord matter may come after.
On request, on request, this after a week.
My lord. All right.
Unappealed.
Otherwise, date may be given, my lord. No
What's the
urgent
matter about?
a matter is, my lord, regarding, my lord, regulation of service, my lord, and they were terminated illegally, my lord. Some of them, professors, my assistant professor, and no further adjournment will be given.
After a week, because this bench we are not 24/1.
Yes, ma'am.
And the other matters also we have passed some orders, maybe same, except 7. 7 supportive was present. 5 and 5 and 6. 7. Please stop. Yes, the matters which you can take up anybody who's there from the petitioner serial wise, because we don't want to cause prejudice to somebody because this is confused. You have a matter?
Yes,
Which
item 3, my.
We can take.
See, I would like to withdraw this matter. Withdraw, my. Because, yes, my lord, with the liberty to file a fresh if necessity arise.
Why, it is liberty, what is the matter about?
My lord, matter, what is the matter? The subsequent development is made out. So,
What is
subsequent
the matter about?
matter relates to compassionate appointment, my. The
The HR Chaudhary, Senate counsel for the petitioner, submitted that he has instructed not to press this petition. Also heard the
I am for the secondary education department, U Sharma.
U Sharma for
Secondary education department.
Training Council, Secondary Education Department. And State of Assam is also a party. And Mr. Chutia was there. And CTC Chutia. Mr. Chutia will record your name. State of Assam is there. You record your name. Mr. Chutia. Item 3. Where is this withdrawal? Withdrawal. Where is this recording your name? Addition. As there is some subsequent pull-up. Announcement. Petition according to closed on it. It is however made clear that closure of this petition shall not bar the petition to approach this court if there is a new cause of it.
May I please, Lordship? Lordship, I am appearing for the matter item number 4, Lordship. Lordship, this is a serious matter, Lordship, regarding denial of admissions to Assam University, Silchar, Lordship. Lordship, if the Lordship
Yes, for the other side, Assam University. Who appeared?
he is in court number 13, perhaps, Lordship, because of some confusions took place regarding.
I'll inform.
He is in court number 13, perhaps waiting for that matter only.
Come after some time.
Lordship.
What is the matter otherwise?
Lordship, this is regarding denial of admission to Assam University, Silchar.
Yes.
Lordship. So, the petitioners have passed BVOC course in Assam University, Silchar, Lordship. There is a provision in Assam University, Silchar. Those who passed BVOC or diploma in engineering, they can get lateral entry to admissions in BTech Agriculture Engineering, Lordship. So, accordingly, the university or the department particularly organized and I mean notified admission, and consequently the petitioners have appeared for that, and as a result they were even given the issued not admit card, but after that the university has not published the result merit list of the entrance test, Lordship. Then the petitioners have submitted representations before the university administrations. Dilly-dally the process. Then the Lordship, the petitioners finding no other alternative have approached this before this court. Then this Honorable High Court was pleased to ask the university to place the merit list immediately. And on that day, an office note was produced by the Standing Council of Assam University, Silchar, Lordship. And he submitted orally that the petitioner's name is not found in the merit list, Lordship. And on that submissions, basing on that submissions, the Honorable High Court was pleased to close the matter with the liberty that the petitioner, if aggrieved by the merit list, can approach the court again, Lordship. On perusal of the office notes, Lordship, it is found that the petitioner's name is clearly shown as selected candidates for the admission in BTech lateral in Assam University, Silchar, under Agriculture Engineering Department, Lordship.
Where is it?
Lordship,
Page?
One second, Lordship. Merit list is at page number 59, Lordship. Annexed 10, Lordship.
59.
Yes, Lordship.
Your name Tulsi.
Tulsi Datta Chaudhary and Abhishek Datta Chaudhary. They are the petitioners, Lordship.
But the reason is different.
Sir, Lordship, the reason is later on shown that due to want of approval,
Right.
their admission is not given. But Lordship, may kindly peruse the prospectus of the Tribhuvan Sen School of Technology. This is the Faculty of Engineering in Assam University, Silchar, Lordship. In page number 43, Lordship.
43.
Yes, Lordship. Annexure 4, Lordship.
Yes.
This is Lordship prospectus for BTech and MTech for session 2023-24, Lordship.
Hmm.
In page 23, it is written that BTech in Agriculture Engineering, lateral entry, duration 3 years, intake capacity 6, Lordship.
Hmm.
So they have notified for the admission process, Lordship. In subsequent pages, Lordship, admission details is given in page number 44, Lordship.
Hmm.
Again, it is written that in Agriculture Engineering, the regular strength is 40, 60, Lordship, and the lateral entry is given 6, Lordship. Then there are some eligibility criteria is also mentioned in the prospectus itself, Lordship, at page number 45, Lordship. So UG lateral entry, Lordship, 10 plus 2, 10 plus 3, 10 plus 2 plus 2, 10 plus 2 plus 3 years in engineering, Lordship.
Hmm.
So the petitioners complied all these requirements, Lordship. Then, Lordship, they have applied as per procedure given in page number 46 of the writ petition, Lordship. That is how to apply, Lordship, in the prospectus. Then what happened, Lordship, they were issued after scrutinizing they have applied, submitting all the relevant documents, their educational qualifications, Lordship. Then they were given admit card, Lordship. Page number 49, Lordship. Annexure 5, Lordship.
Okay, let him come here first.
Lordship.
Please inform Mr. Kyle. Have you done sometime?
Lordship. Obliged, Lordship.
So I received the instruction, my lord.
Yes.
Now petitioner can, my lord, apply because, my lord, they says, my lord, in departmental candidates there is no age bar. Provision of
Lord.
administration.
We'll record that.
Lord. Yes.
Heard free as Botakut. Then it comes for the petition. There are also heard. Also heard. 3 Turkey. And additional senior candidate. Assam. Para. Considering the subject matter
That's the point.
and the written instructions obtained by the United States of this petition is taken up for disposal at the motion. As per the facts projected in the petition, an advertisement was published. Please have your seat. An advertisement was published on 5/9/2023 by the APS for fitting up scientific officers under the Directorate of Forensic Science, Government of Assam. The advertisement stipulated the upper age limit for general category candidates as 38 years as on 1/1/2023. It is the case of the petitioner that on the stipulated date, he would be overaged by 47 days, and accordingly, he had submitted a representation dated 7/9/2023 for condonation of her overage in terms of the government notification date 3/5/1951 of the Personnel Department. Since no action was taken on the representation, and in the meantime, the recruitment process was progressing, the instant it has been filed. The Bothakudi Learned Council for the petitioner has submitted that the margin of overage is minimal, and under the notification mentioned above, powers are vested to confront the age, and in the present case, exercise of such powers was warranted. It is warranted. The Executive State Council has, however, submitted that as per the earlier orders of the court, written instructions have been obtained by placing a copy of the state instructions along with a corrigendum dated 3/10/2023, it is submitted that so far as departmental candidates are concerned, there will be no upper age bar. In terms of age submission, and also having a look at the corrigendum dated 3/10/2020 on the courts of the opinion that the grievances of petitioner can redress. So according to the state petition is closed. There are copy of written instructions dated 4/10/2023 along with a copy of corrigendum dated 3/10/2020 are made part of the report.
Deeply obliged.
Deeply obliged.
May it please your lordship. Your lordship may kindly pay.
Let us try. BJ Fukan. Yes, yeah, Mr. Fukan.
Sir, on behalf of PJ,
Yes, yes.
who will file our affidavit in
We should file new. I had not paid the court.
no, we'll file.
So you will file.
Municipal type.
You have filed or not?
No, no,
You will be filing. How much time?
2 weeks. 2 weeks.
2 weeks.
May
Third, three Deuri Learned Council for the petition. Put the para. 3.
A. Ahmed.
A. Ahmed appearing on instruction of TJ Standing Council, Guwahati University,
KKHSU.
KK Hanti Open University. However, praise for and is granted 2 weeks time to file affidavit of which.
May I pay for a please, your lordship?
Proof of certification.
Deeply.
This immediate
Deeply.
wait for some more time. There is some
May I please? Well, my promotion has been put to challenge by the petitioner, who has not been selected and been junior to me. my
Where
lord.
who is the petitioner?
Petitioner is my colleague, my lord. He is
Where,
junior
where?
to me.
Where is your colleague? Invisible colleague.
No, no, colleague.
Where is your colleague?
Oh, colleague, my lord. He has met me just now. my lord.
Mr. India,
Yes.
we don't have a respect. Let him come. Let him come. Because there is some confusion.
This not some instruction was stopped.
You got the instruction?
No, my lord. The SMT system was holding. Hospital take up.
Yes, invisible
Yes,
person.
yes.
He was arguing.
Yes, I'm sorry for the
So can you take this up or you want time to get the instruction?
So there is a direction to place one instruction. my lord. That instruction we have not.
Let him get the instruction.
But in the meantime, my lord, what happened? That there is no interim order in this case, my lord. But my lord, the client of my planet friend is taking the acquittance register of the school, my lord, and not allowing me to get my salary as headmaster, my lord.
You file an IA, we'll look into it. File an IA. Place this on record. You have to place this on record, then only you can pass some orders. Clarifying that there is no interim order, number one. And number two, your salaries cannot be withheld unless there is an order.
The salary they are giving as assistant teacher, but
Not
not
as
as
headmaster.
headmaster.
Whatever you have filed third Learned Council for the party. Be costed. Learning Council, which department? Secondary Education Department, have praised for and done to further 2 weeks time to obtain the instruction.
And any date after vacation, my lord.
List immediately after.
Obliged.
Obliged.
Thirteen. Super. Yes. Anybody the other side? What is 13?
I've received the instruction.
Quite definitely.
I think not necessary, better because the claim has already been the relief which they have
Based on the
taken.
instructions, can we take it up for further?
Yes.
Let them come and take a chance.
Right.
Maybe they are not aware.
Right.
Yes.
Proceed.
Which one?
Item 14.
Outside.
My lord, respondent number 2 file an affidavit, my lord, Director of Elementary. I will I'll reply, my lord. So,
And that is for 5.
Yes.
You have
I-
filed affidavit.
Yes, I have.
yesterday I received. a copy.
And would you file rejoinder to this phone number 5 affidavit?
Yes, my lord.
5 affidavit. So
I will
director is
file-
that
I will file affidavit, my lord, after 2 weeks.
you had requested for time for filing affidavit so far as director's affidavit.
Direct.
What about response number 5?
Phone number, my lord.
5 is the director. You are the
Lordship,
director.
I am for the, my lord, private respondent, my lord.
What about private respondent to file gender?
Fine.
Okay, we'll grant you time to file the gender. What is your name?
YLE.
On the prayer of by Ali and ask for the petition. Matter is adjourned by 3 weeks to enable filing of the gender.
File.
Top of the list.
May I please your lordship? Lordship, last occasion inspection of third for lordship.
Affidavit 57.
What is the matter?
Matters lordship, we have challenged the gradation list dated lordship 31/8/2022 lordship.
Of?
Of 2022 lordship.
No, no, gradation list of what?
Of the lordship gradation list of promotion of the teachers of LP school, and they are serving in LP school lordship. After the amalgamation, they are the teacher of ME school lordship. When the time come to the gradation list, preparation of gradation lordship, petitioner are approached before the BO as well as the DI Dhuhuri lordship, and the respondent authority lordship rejected his prayer on only one ground lordship. Ground is that they are earlier serving as a teacher of LP school lordship. This is the grounds lordship. And lordship, kindly come page number 20 lordship. Notification dated
You have
28/20.
taken first step. You have not taken first step.
We have taken a step.
Hmm?
Already we have taken a step. Lord.
No, because you have to look at the order.
Bolum. Step bolum.
Have a look. You take first step.
For a moment, lordship, kindly see lordship page number 20 lord.
No, no, without step, how can you go ahead? Take the step first. There is an order, you have not appeared to the laws.
Yes, Lord.
It is challenging the gradation list, my lord.
Yes, any development?
No, my lord.
As per the order, it's 25/9/2023 of the learned Lozima Court,
Service notice.
first step by registered post with AD as well as
लेकिन why?
usual process
Okay,
have not been taken by the petitioner for service of notice upon the response numbers 16 and 24. Further, neither unserved notice nor AD card have been received back. So far as response numbers 20 and 23 are concerned. So the parent council 3
A Alim Mr. Lordship, A Alim Sheikh. Lord.
A Alim Sheikh accordingly placed for is according direct to take step by registered post with AD as well as usual process upon the response number 16, 20, 23 and 24.
16, 20,
23 and 24. Get the order downloaded and take step by registered and steps by tomorrow.
Plus
list after 4 weeks along service My Lord, in this matter, my Lord, we have challenged the selection and appointment of respondent number 5 as principal of Golaghat Engineering College. There, my Lord, are other respondents are there, not, my Lord. Appeared or not?
And
Yes,
they have
they
appeared, Lord.
appeared, my Lord, they
appeared.
filed the affidavit, my Lord. But today, my Lord, perhaps there is some confusion today. Due to some confusion, my Lord. We'll have some other day, Lord, my Lord, after the vacation, my Lord.
Lordship.
On a prayer made on behalf of petition. This after
Lord. Oblige.
deeply applied. Take up Senate Council, Senate Council, Higher Education.
Lordship. Oblige.
Matter, Mr. H.R. Chaudhary Sarul Arpita matter. He's on lax in court number 4, your lordship. For the time being, your lord.
Yes.
For the time being, your lordship. H.R. Chaudhary Sarul is on lax.
Number
16.
other side. Affidavit filed.
Affidavit filed. For the time being.
What's the matter?
What if this matter relates to non-provincialization of the services of the petitioners who were otherwise recommended by the district scrutiny committee and thereafter recommended by the state level scrutiny committee?
Can we take up for final disposal?
What will be taken? At 2 or lordship?
Not only
Of lordship. He'll become.
for a time being.
Lordship.
— 17.
Instructions have been received.
17, item 17. You have received instruction.
My lord.
Like to file affidavit.
I would like to place it only, Lord, for
Item 17. Non-APS for the petition not for
we'll bring it on record otherwise.
whereas the Senate Council
Elementary education, Lord.
limited education is present along with instruction.
My lord.
Madam, you are also the
Yes, your
SSA
lord. SS.
also present. MS. He does. What yes. It however this court however there is some confidence with regard for there are please Dr.
CPM, right? Your lordship, affidavit filed, your lordship. We have also filed our reply, your lordship.
you want to take up for disposal?
Lordship. It can be on summer day. Or your lordship can take it up.
Whenever.
Otherwise, issue is like this, your lordship. The petitioners are your lordship graduates, your lordship, with DL, DH, CAT pass, along with your lordship Hindi, Provin degree, your lordship. Now, these qualification, your lordship, so far as the other, your lordship, for appointment to the post of assistant teacher of your high schools, your lordship, is considered, your lordship, as per rule of 2003, as well as the recent rule of 2000, latest rule of 2018, your lordship, secondary education provincialization rule, your lordship. Now, so far as your lordship, upper primary teachers are concerned, your lordship, Hindi teachers, your lordship, they are not allowed to participate, your lordship. That is the crux of the issue, your lordship. While they were allowed to participate in the selection process for these qualification in the high school teachers, your lordship, but for upper primary teachers, they are not allowed, your
Yes,
lordship.
what are the reasons?
They say, your lordship, that NCT, they have, your lordship, it is under the NCT guideline, your lordship, we are not entitled, your lordship. Probably, your lordship, that is not.
NCT is anybody appearing for NCT.
NCT guideline, your lordship, which
Is anybody appearing for NCT?
NCT they have not NCT we have not made.
Not party.
Not. But NCT guidelines are there, your lordship, and your lordship will kindly see, your lordship, at the same time, Karbi Anglong Autonomous Council and the Bodoland Territorial Council allows these people to participate in the upper primary teachers, Hindi teachers post, your lordship, and all other
Irrespective of the guideline.
irrespective of that, your lordship. And your lordship, NCT guideline never says, your lordship, they say that Hindi should be one of the subject in the graduation, your lordship. That is not there in the rule, your lordship. It is in the advertisement they put it, your lordship. Now, neither BTC nor Karbi Anglong Autonomous Council in their advertisement has put such stipulation, your lordship. Even other states, your lordship, Manipur, etc., your lordship, they have also allowed these people to participate in the upper primary teachers course. Only so far as this.
The rule will follow or guideline. Unless you incorporate in your rule the requirement of the NCT form of guideline. Can it be statutory enforced?
No, the NCT guidelines prescribe that the Hindi must be a subject in the graduation, and that was incorporated in our advertisement. They have not challenged any clause in that advertisement.
But what about the rule? Does the rule prescribe?
Yes, our rule says as prescribed by NCT.
Now, your lordship, NCT guideline they have not annexed, your lordship will kindly see their affidavit in opposition, your lordship. Except making a vague statement that we have.
Have you got the guidelines?
Not.
Get a copy of the guidelines. In fact, that should have been your forte in the affidavit opposition. If you are depending on the NCT guidelines, right, that the graduation petition is that's your main defense.
Basically, the prayer in the repetition, if a lordship finds at page 33.
You have to produce the guidelines.
Lords, they are
when?
seeking a declaration.
When? Next Tuesday?
Yes, Lords.
Today is what?
This Thursday.
No, today is 5th. 10?
Lords.
The buildings have taken and the party, the learned council for the party are in agreement that the matter can get up for disposal at the admission stage for compare. The big costing the sending council higher education elementary education department, however, submit that the impute action is based on the guidelines by the NCT. So the next date, the same guidelines may be produced.
Lord, lovely.
Yes.
Maybe. This is my lord, regarding compassionate appointment of the petitioner, my lord, participant, this honorable court, my lord, directed to place the matter before the DLC. My order dated, my lord, 15/11/2021, and thereafter, my lord, it has been placed before the DLC, and DLC, without, my lord, going into the merit of the consideration of the case, my lord, has rejected the case of the petitioner on the ground that there was some FIR against the petitioner, and on the ground it is rejected. But my lord, there is no FIR registered against the petitioner as on date, my lord, number one. Number two, my lord, the DLC has to function within the framework of the guideline, my lord. Their duty is
no, but you have stated in affidavit that there is no police case.
There is no police case. There is no police case.
My lord, as per our affidavit, my lord, FIR has been lost, my lord. FIR has been lost, my lord. Again,
FIR is there.
My lord.
Letter is submitted, my lord, as per minus statement, my lord. Letter is submitted, but letter has not been registered as FIR.
Who is responsible for 5? R5.
My lord.
Rohan Kumar Jha.
My lord, deputy commissioner. Deputy commissioner filed affidavit.
Okay.
Regap number 8, my lord, state that.
In that he has stated about the FIR.
My lord.
Where page?
In this, my lord, page number 46, my lord.
46.
46, my lord. Affidavit filed by the respondent number 5. sir. Page number 46, relevant paragraph, page number 8. sir.
Paragraph 8.
Page number 46, my lord, got it.
No, regarding the FIR.
FIR, my lord. There are 6 lines from the bottom, my lord. In this regard, one FIR was also lodged by the Director of Elementary Education Assam against the Sohail Alam Raspe and three others at Kispur
By
Police
the
Station.
director, oh, it's not a private kind of a dispute. By the director.
By the director.
What is your name?
Suel Alam, my lord.
There is a case against you.
My lord, that is not registered, no case registered, my lord. I've inquired. The petitioner has inquired, no case registered. They have to just simply sent a letter.
No, this statement is made by a responsible officer.
Yes, without annexing the any.
No, but he's a deputy commander. We just cannot classify this
Yes.
statement.
Against that, we have given
Can you take the instruction whether it's registered or not? Otherwise, also it's mandatory to register all efforts.
My lord,
In
definitely.
fact,
my
this
lord.
has been
Considering the
misused.
offense.
False efforts has been lost, and after registration has been abused. Also. But registration is compulsory.
Right.
To take the instruction, get the police case number.
Right.
Hard review as well. Who has filed this petition with a claim for punishment from the state council.
Second.
State council, however, by reference, affidavit in opposition filed by the respondent 5, dated 6/2/2023, has submitted that an FIR was lodged against by the Director of Elementary on the issue of certain documents produced by the petitioner for his claim on compassionate appointment. The State Council has also referred the averment made in paragraph 8 of the that this matter will be after 2 weeks to enable the United State Council to get the details of the case registered. If there is no case registered, then perhaps that may not be a relevant factor. Yes, Mr. Dev, what is this?
Pick the matter after vacation, Lordship. Some consideration is going on the secretariat level, Lordship.
You file affidavit.
Lordship, we will file affidavit, Lordship.
Today, let him file.
Yes, my lord, but lordship may kindly fix the date because he's scheduled to retire in the last part of this year.
Lordship, after vacation, we will.
Heard. As the
My lord.
Senate Council for the petition. Mr. Rastov for
a private resident number 3 and
you file affidavit. Have you filed your affidavit? No.
but we have we have submitted our
Have you filed your affidavit in this case? Will you file or not?
the record.
No, if you say you will not file, then we'll record. It's up to you.
Let me take another.
We'll make it open for you to file it. Also heard Senate Council, Higher Education Department, as well as V. Rastov, Senate Council for the respondent 3 and 4. Sarah, the Senate Council for the respondent, however, pray for cannot granted. Pray for time to file affidavit in opposition. 3 days, the Senate Council for the petition, however, informs his court that the petitioner is to retire from service by the end of this year. Considering the same, that the matter be listed immediately after the petition By which time, comma, affidavit of which may be filed.
Lordship, will it be possible to fix the date?
Date depends to matter, but not
Another
before a date.
2 years service is there, 57 years, 22.
Not this year.
No, Lordship. 22.
I am instructed that he will retire this year. my lord.
What is
Petition,
the age?
as per the affidavit, it's 57 years, Lordship, not 22.
Lordship, but there is something, my lord. Really.
That will be a wrong submission. We don't want to record a wrong submission.
No, my
Neither
lord,
we,
I was just instructed.
neither
that-
we want you to make our own submission.
Lordship, Lord.
So don't say by the end of the year.
57,
is-
they have filed.
They say that he submit that the petitioner date of retirement is also approved.
Lord. Lord.
I'm obliged.
That this writ petition is preferred against the order and judgment and order passed by the Educational Tribunal, my lord.
Okay.
Whereby writ petitioner's services were declared to be illegal and termination of the respondent by the managing committee of a school which was not provincialized, that was also declared to be illegal under the Rule 24 of the Assam Non-Governmental Educational Institution Management Rule, my lord. The basic fact,
Mr. Take you for the private respondent.
Private restaurant number 5, my lord.
And who is for the department?
I'm-
Can we take up for final disposal?
Yes.
Can we take for final disposal?
Yes, my lord.
Today?
It is to be, my lord, because their service was terminated. But, my lord,
his service was
about 1 year, my lord, due to status quo, I am out. And though order was in my favor, I am not getting any benefit of that. So, my lord, it may be disposed of.
Now, if you want, we can take it up for disposal
Yes,
today.
yes.
itself. Mr. Sharma, are you ready?
And government also filed a short affidavit, my lord. I have also. my lord.
The Khatana, if you want, we can
yes,
go ahead.
ma'am. My lord, I'm led by my senior MK Chaudhary is coming. In the meantime, I can apprise your lordship of the facts of the case.
Up to you if you want to proceed or you can have to after some time. Whatever you.
Let my friend place the facts, my lord. Senior counsel will say about the law.
My lord, in this case, the respondent number 5 was appointed as assistant teacher of Bapuji High School, my lord, which was non-provincialized on 10/9/1992, my lord. That is at page 132, my lord.
10/9/92.
92.
Respondent number
5, my lord.
Was
Ramanand
appointed.
Shah. Page 132. my lord.
Appointed.
Appointed by assistant teacher, my lord, by the managing committee of the school, which was not provincialized then. And thereafter in 2000,
What is the name of the school?
Bapuji Hindi High School, my lord.
Where?
My lord, in Jagi Road, my- under Morigaon district. And thereafter,
It was a venture school at that time.
venture school, my lord. And thereafter on 22/6/2001, my lord, the 22/6/2001, my lord, the respondent number 5 was allowed to hold headmaster in charge by the school managing committee, my lord. That is at page 8 of the IA, my lord. One IA was filed. And on 1/6/2007, a resolution was adopted by the school managing committee suspending the respondent number 5. 1/6/2007, my lord.
After 6 years.
Yes, my lord. A resolution was adopted suspending him for some activities, my lord.
R5 was suspended.
R5 was suspended. And on 13/8/2007, inquiry report was prepared by the joint director of Director Secondary Education, confirming the allegation against respondent number 5. Well, that is at page 70 of the report.
Yes. And in the meantime, this school was provincialized.
No, my lord. It was provincialized in 2013. my lord. And thereafter, on 22/8/2007, a resolution was adopted by the school managing committee removing respondent number 5 from the post of headmaster.
removing R5.
R5, man. And in the meantime, my lord, on 22/9/2007, the Assam Non-Government Educational Institution Regulation and Management Rules came into force, my lord.
Rules of which year? 2007.
2007, it came into force by gazette notification on 22/9/2007.
Yes.
And the basic crux of the matter is that this removal was declared to be illegal under this rules, my lord, 2007. Although removal was prior to the coming in force of this rule, my lord. That is the basic case. And thereafter, on
The rules you say came into force on 22/9/2007.
and
And the impugned action of the respondent of 5
of removal,
is of 22/8/2007.
7,
And the removal has been prepared with by
education
taking into
tribunal.
consideration by rules
Yes, my lord.
which were not existing at the time of
No retrospective effect was done. And thereafter, my lord, on 13/30/11/2007,
30/11.
2007,
Yes. Yes.
the petitioner was appointed as the headmaster of the school, my lord. That is page 150 of the writ petition, my lord.
Yes.
And the respondent number 5, my lord, in the year 2014, after a gap of 7 years, came to challenge his termination, my lord, as headmaster of the school. And after provincialization of the school, that is on 2/6/2014, my lord, he filed a writ petition 2026 of 2014, challenging his termination, my lord. That is
WPC
26 of 2014, my lord. And the school was provincialized on 22/9/2014, my lord.
It was after 7 years.
Yes, my lord. And school provincialization order is at page 20, my lord, of the writ petition.
Provincialized when?
Pardon, my lord.
When was it provincialized?
22/9/2014.
Yes.
And thereafter, in this writ petition, my lord, order was passed on 4/8/2016,
Remanding.
directing the
Education Tribunal.
Educational Tribunal, page 131, my lord. And the impugned judgment is at 28/2022, page 176, my lord.
Dated
28/2022, my lord,
by the tribunal.
by the tribunal. And this order is being challenged in this present writ petition. If I may take your lordship to page
The,
176, my lord.
Tribunal allowed the petition.
The tribunal allowed the petition.
Page
176, my
lord.
Operative part starts from page 177, my lord.
Yes.
Here the petitioner was respondent number 5, my lord.
Yes.
And it says the petitioner is entitled for the relief as follows. Resolution number 322/8/2007 is illegal and accordingly
Shall
set.
see the judgment?
Yes. Judgment starts from page 181.
Yes.
The instant petition was filed by the petitioner in terms of the order dated 4/8/2016, passed by the Honorable Guwahati High Court in writ petition 2026 of 2014 to approach this tribunal for his grievances. By this petition, the petitioner has prayed for setting aside the resolution number 3 adopted by the school managing committee of Bapuji High School, Jagi Road, in the district of Morigaon in its meeting dated 22/8/2007, by which the petitioner was removed from service as headmaster of the school. Petitioner's case in brief is that he was appointed as assistant teacher of Bapuji High School, Hindi Medium, Jagi Road on 10/9/92, and thereafter on 22/6/2001, he was appointed as headmaster of the state school by the school managing committee in the year 2005. the SMC of the school was reconstituted, where petitioner was appointed as member secretary. However, the said SMC was dissolved before completion of its term. Against this, the petitioner filed a writ petition by number 2553 of 2007 for dissolving of the said SMC, wherein this court passed an interim order dated 1/6/2007 with direction to maintain status quo. On the very date, the SMC held a meeting and took resolution whereby petitioner was suspended for 3 months. Where petitioner was after his suspension, the respondent number 3, 4, and 5 insisted him to withdraw the writ petition and assured him that after withdrawal of the writ petition, the suspension of the petitioner would be withdrawn and he would be reinstated. On the basis of that assurance, the petitioner withdrew the writ petition on 10/8/2007. However,
My Lord, I was in court number 13 for this item, my Lord. I was sitting there. In fact, my Lord, court number 13 also granted adjournment from this place. From your Lordship list.
No, the notice is slightly defectively framed. There is no object in writing that matters of this court to be taken up by.
That notice is there, my Lord.
Should not have been there because there is no separate list of this court.
Yes.
We have been given a list of bench 2, which itself is special.
I have no problem, but I was not here because I was waiting.
No. We were told we had granted all adjournment. All matters.
Now, perhaps my learned friend.
Yes, Mr. Khatun has already placed the basic facts regarding the appointment, how he was removed, and he has pressed on the fact that the removal, everything was done before the rules had come into existence. And the tribunal, he just hinted the tribunal had gone into the examined the aspect in the context of the rule. That is the
Yes, that is primarily, my Lord. Therefore, the issue that falls for consideration with your Lordship is that, my Lord, whether the claim of the respondent number 5 can be, my Lord, considered on the basis of the rule which came into existence subsequent to his termination. This is the, my Lord, primary issue.
But see, there was a remand from the High Court.
My Lord.
There was a remand from the High Court.
Yes.
And remand order was not put to tell.
Yes.
It was at a stage before the rules had come into the force. The actual cause of action.
Yes.
And in the meantime, when the matter was pending in the High Court, the rules came into force.
Yes.
At the time of remand, this particular aspect perhaps was not gone into.
No,
Whether it's the case, whether which should be looked to by tribunal or a civil suit implement. But so the remand order, won't the tribunal be within the confines of the High Court order that you have to examine?
No, my Lord, the
tribunal cannot be a civil court.
My Lord, this court, the Honorable Court has, my Lord, remanded the matter because the jurisdiction has gone to the, my Lord, Education Tribunal. Nothing has been said on merit. And we didn't have any objection to that. Although, my Lord, the question of limitation was there, termination.
No, limitation, those points are separate points which we'll consider.
My Lord.
But once the remand was made by this court, and though the rule, till now we have not seen any retrospective effect. But tribunal examination will be on what context? Tribunal look into the matter per se as a dismissal, as a case of removal, or under some particular rule.
Now, my Lord, so far as this termination is concerned, at that point of time, my Lord, this particular rule was not in force. But
what is in force? How were they guided at that point of time?
At that point of time, my Lord, in my humble submission, there was an act that does not really help, my Lord. If your Lordship, my Lord, comes to the Act of 2006, that does not, my Lord, really say, my Lord, this is a non-government education institution regulation and management act.
May I point out one thing? When your Lordship remanded back the matter to the tribunal, at that time, your Lordship discuss about section 15 of 2006 Act. So section 15, it is reflected in their order of remand.
Okay, we'll be here. Yes, which page? This page, this book, 573.
572.
Yeah,
It's in the
Yeah.
Act, my lord. Assam Non-Government Education Institutions Regulation and Management Act, 2006. Your lordship may come to Rule 13. Power and functions of the managing committee.
Rule, section.
Section 13 and 15 will be relevant. Section 13, your lordship will find at page 588.
Yes.
Powers and functions of the managing committee. The managing committee shall have control over the appointment of the employees, disciplinary action against the employees, and overall administrative control of the affairs of the institution. Then your lordship may kindly come to section 15. Appointment and disciplinary matters. The school authority shall issue appointment letter in the event of any appointment made to any person in regard to these affairs, and such appointment letter shall clearly state the terms of appointment, salary, and other conditions of service in respect of such appointment as per scheme of the management of the institution. The subsection 2 will be important. No employee of a non-government educational institution shall be dismissed, removed, or reduced in rank, or terminated without giving him a reasonable opportunity of being heard, and without the matter being referred to the managing committee for its consideration and approval. Then proviso is regarding suspension. Then, my lord, subsection 3, the procedure to be followed in disciplinary matters shall be such as may be prescribed. It means that, my lord, it has to be prescribed under the rules. So although, my lord, the Act was of 2006, rules came into being only on, my lord, 29/10/2007.
Yes.
Therefore, at the relevant point of time, when the Person number 5 was terminated from service, that is on, my lord, 22/8/2007.
Termination on
22/8/2007. The learned tribunal, if your lordship looks at the matter operative part of the order, your lordship will find out there are two aspects. One is, my lord, whether these rules can be, my lord, applied retrospectively. And secondly, what will be my case? Because my service has already been provincialized. So that part, my lord, how the tribunal can touch, that is another aspect. May I take your lordship to the, my lord, operative part of the judgment?
Yes.
The judgment starts at page 179. The findings and the operative part, your lordship will kindly see the issues framed at page 184. On these pleadings, by the order dated 5/5/2018, the following issues were framed by the then presiding officer. Whether the present case filed by the petitioner is maintainable in its present form and whether there is any cause of action for filing such a case by the petitioner, whether the Bapuji High School Hindi medium situated at Jaggi Road under Jaggi Road PS was established and or if established, when and how, whether the petitioner was appointed as headmaster of Bapuji High School as per resolution of the respondent number 5, School Management Committee and approved by the respondent number 3, whether the respondent number 4 resigned from the post of headmaster and if so, why. Respondent number 4 is the my lord now the petitioner. Whether the present case is affected by misjoinder and non-joinder of necessary parties, whether the petitioner is entitled to get any relief. Now, my lord, your lordship will notice, my lord, no issue was framed on limitation. Although a specific ground was taken in the written statement at page 135, your lordship will find that. May I take your lordship to the my lord for the time being?
Where is it? The ground or
135, my lord. In fact, this is the my lord written statement. Paragraph 9 at page 136. No, sorry. Paragraph 5. That the case is barred by limitation. So this no issue was framed on this. Now the findings of the learned tribunal, your lordship may kindly come to page 192. Paragraph 19. Before going into the minute, may I read it, Mike?
Yes.
Before going into the minute details of the case, as the whole case is based on alleged non-compliance of various provisions of Rule 2007, let me first quote the relevant provision of the above rule. Chapter 9 of the Rule 2007 provides for procedures to be followed in disciplinary action against employees under Section 15(3) of the Act of 2006. Then Rule 17 has been quoted in paragraph 20. And 21, Rule 17(2) provides that no order for suspension shall, this is not relevant. Paragraph 22, Rule 17(4) provides that a penalty of dismissal.
We may not be too much inclined in going through the session of the rules which are not even there.
Yes, my lord.
We would only like to see whether the tribunal looked at the aspect of following the principles of natural justice, whether he was given reasonable opportunity. Non-existent rule cannot take into account that.
Then I'll not.
That is not an issue at all.
On that. Then, my lord. Then,
but we have to ensure that the tribunal was satisfied that before he was removed from service, he was given the reasonable opportunity, which is the mandate of the Act.
Yes.
Act has the procedure framed by the rule.
Yes.
Rules were not there, so we cannot go into the rule. A fundamental error, I think, tribunal has committed by going through a procedure of rules which are not even in existence.
Yes, my lord. That on that.
We do not know what rules are going to be framed tomorrow. How can today we follow them? But what would be necessary is whether he was given reasonable.
Now, my lord, the entire finding of the tribunal is on the basis of the rules. Your worship may kindly come to paragraph 30 at page 197. This is the operative part. Because there are two aspects. One is, my lord, allowing his petition, private responsibility.
Who is for the managing committee for the school?
No, in fact, my lord, this has been filed, the education, my lord, the application before the tribunal was filed in such a manner, if your lordship kindly comes to his application, and the party that was there in, therefore, my lord, the petitioner, principal, then the school managing committee and the headmaster, they are all, my lord, petitioners before law.
Here,
Yes, my
in this,
yes. That is because, my lord, these three were made the
so you
respondents,
should be having the records of the proceeding.
my lord.
Should be having the records of the.
Records of the proceeding we brought on the last occasion. Ajay Hassan. Records were there because
We have to have a look at the records. If the record does not suggest that he was not given reasonable opportunity, then irrespective of the fact that rules have been taken into consideration, not that part leaving aside, you may something else, but see that he was given reasonable opportunity and thereafter he was moved. Then
no, my lord, there is another aspect. No, that's why I am imploring that your lordship will kindly read paragraph 30,
Please do.
actually 197.
Yes.
Thus, without going into the details of the documents proved by both the sides, this is important. Other factors have not been considered.
Page 197.
Yes.
Paragraph 30.
Paragraph 30, 30.
Yes.
Thus, without going into the details of the documents proved by both the sides and the allegation and counter-allegation against each other from the facts as discussed above, it is proved beyond doubt that in this case, the SMC of Bapuji High School Hindi Medium has acted in a haste, but not by not following the prescribed rules as narrated herein before. The SMC even did not follow the advice of Inspector of Schools given by Exhibit J and thus acted beyond law. The action of the removal of the petitioner by SMC by the resolution number 3 dated 22/8/2007 is absolutely illegal. The same even violated the principles of natural justice. As such, action of the SMC by which the petition was terminated cannot be allowed to stand and accordingly set aside. Now, I would like to mention here that for the purpose of brevity of judgment, I have avoided discussing the various evidence and other documents proved by either side due to arrival at the decision on the prima facie failure of the respondent to show fairness in the action of removal of the petitioner. Now, my lord, here, as my lord, beg to point out, I'll take your lordship to the application. My appointment was not under challenge. That's why, my lord, I am imploring that your lordship will read this. 32. In consequence of my above finding, by setting aside the resolution number 3 by which service of the petitioner Sri Ramananda Jha was terminated as illegal, the consequential action taken, that is approval of Avdesh Kumar Singh as headmaster, also held to be illegal and liable to be set aside, which I accordingly do. This is beyond the prayer. If your lordship kindly goes to the application page number 1. My service has been provincialized already, and that is not under challenge. And the tribunal sets aside my appointment. His application before the tribunal starts at page 22 and the prayer is at page 36. It is therefore that your honor would be pleased to admit this petition call for the records, issue a notice to the respondent to show cause as to why the impugned resolution number 3 adopted the SMC meeting dated 22/8/2007 of Bapuji High School, Jagir Road in district Morigaon shall not be set aside, as to why the services of the petitioner as headmaster of the school shall not be provincialized, and the show cause as to why the provincialization of the service of the respondent number 4 shall not be set aside, and the perusal of the records reply show cause after hearing the parties. These are the prayers. Set aside the said resolution. Direct official respondents.
Number 3, prayer number.
No, what I mean to say is, my lord, this prayer is there, but my service was provincialized and my original appointment, that has not been, my lord, challenged and brought into record. In fact, my lord, the provincialization order due to annex of 90 provincial, no? The provincialization order is perhaps also, my lord, not on record. I'm just saying, maybe your lordship will kindly bear for a minute. I think that is not on record. Hmm? The order of my provincialization of service also, my lord, that is not annexed.
You would like to have a record of
My lord, that is one aspect, but my submission will be, my lord, here is a case where the, my lord, the tribunal has said that without going into the evidence have been laid.
I would like to have
It can be
I would
remanded,
like
my
to
lord.
have a
It can be remanded back. And my lord, what is the factual position today, my lord? Today, the private respondent has already, my lord, attained his age of superannuation. That he has got.
you've retired.
Yes, my lord, when this writ petition was filed, when the tribunal passed the order, at that time I was in age, my lord. I was in service. But subsequently, when the writ petition was filed, your lordship was pleased to pass an status quo order. When status quo order was passed, my lord, the writ petitioner
He continued.
continue in
As a
position, my lord. Continue in position. So, my lord, that status quo order was 16/9/2022, about 1 year. Now we are for hearing. So, my lord, in that case, my lord, now I retired from service. Thing is this, my lord,
He has not retired. He has attained the age of superannuation.
that is the end of superannuation is the function of the words only.
No, no.
So, my lord, here your lordship
That makes a
will
lot
be
of
pleased
difference.
to, that will make a lot of ocean, no problem. Your lordship, actually,
But at this stage, Mr. Sheikh,
but what your lordship pointed out, your lordship would be pleased to see the record of the proceeding. And after that, my lord, it will be clear. Only one point will be clear, that reasonable opportunity of hearing, as provided in section 15 of the 2006 Act and rule 13 of this 2007 rules, was not at all complied. Not at all complied with. And very interesting thing is this, my lord. As on today, my lord, they could not produce, the petitioner could not produce the termination order in the record. Termination order, I was terminated. So, my lord, a resolution has been taken in 2007. Matter was fighting going on in High Court as well as in tribunal.
Correct.
In tribunal, my lord, I was not served with formal termination order. That is one aspect of the matter. Supposing they do not like to serve me this termination order, there is some practice that if termination order is served to him, immediately it will go to the High Court and immediately it will be state. That may be their strategy. But unfortunately, my lord, in the tribunal also, in tribunal's order, your lordship would be pleased to see, in tribunal order it is mentioned that formal termination order is not produced by the managing committee in the case record. That is why, my lord, tribunal observed. So I am to pass my judgment on the basis of the impugned resolution. So resolution was set aside. Termination order was not served to me, not produced before the tribunal. Even as on today, my lord, formal termination order is not on record. So, my lord, your lordship would be pleased to see. It's a clear, simple service to students. If somebody, it is determined by the authority that you will be terminated, that is all right. But everywhere, this is the norms. That yes, this is the termination order served to you. As on today, they did not have the formal termination order. How they are acting, my lord, it is very surprising. So, my lord, my humble submission.
Resolution was not communicated to him.
Yes, not communicated. Even today, my lord, in the record, in the High Court record, they did not place this termination order. That is very unfortunate. Did not before the tribunal. I was not served. That is the practice matter. That I will go to the High Court and stay the termination order. May not be served. But why not before the tribunal, not before the High Court?
Do you have a copy of the termination order?
My lord, the termination was by way of a resolution. In the resolution, my lord, in the back meeting, he was present, he has signed it, and he has brought it on record, my lord, by filing a miscase.
But isn't the resolution needs to be communicated by an order?
No, my lord, first, another aspect, your lordship, my lord, in this context, his claim is to the post of headmaster. Let him show one document that he was appointed as a headmaster. He was not appointed as a headmaster. Only for the time being, he was given charge.
Yes.
He was given charge for some time. He was not appointed, my lord.
There is no substantive appointment.
No, the only document which has been relied by them, your lordship will find that, my lord, is.
Said that on 22/6/2021, 2001.
2001.
Page 8 of the IA. Page 8 of the IA, you have said.
Allowed to hold.
Yeah, are allowed to hold charge of it.
Yes.
Page 8 of the IA.
At my lord, page, that is also available at page 119 of the read petition. I mean, of the read petition.
What was the allegation?
Serious, my lord,
Allegation was not served to me. No search served to me.
the resolution contains, my lord,
No, my
all
lord,
the
nothing.
resolution.
Yeah, on 5 points,
Misappropriation of money,
My lord.
primary.
my lord, my humble submission before your lordship. I may be very bad man.
You get the record.
Yes,
Get the record.
yes. My lord, my prayer will be
Record has to come from the tribunal.
We don't want tribunal record. We want the record of proceedings that we get for. Tribunal record we are not. Did you produce the records before the tribunal?
Some records we had produced, my lord, not.
Please have a look. If whatever is there, I think it's there. No, these are the. These are the.
Proceeding book and peon book, those will be required because, my lord.
We are just in the how you have treated the resolution. And before that, did you give him a chance? Heard MK Chaudhary and counseled by M. Khatania, the petition. Also heard U. Sharma, the training council for secondary education department, whereas M. Ishik, council present for the response for 5.
yes, ma'am.
The petitioner has put to challenge a judgment and order dated
20th of August 2020.
28/2020 passed by the Learned Education Tribunal, Morigaon, in a petition filed by the respondent 5. The said petition was filed pursuant an order dated 4/8/2016 passed by the in WP 2015, in which the present response of 5 has challenged a resolution taken by the management committee of the Bapuji Hindi School, Dagi Road, by which he was removed from the school at the stage was a venture fund. The primary condition of the account are that while allowing the by the comma, Reliance has put on the rule which came into effect only on
2019.
29.
No, my lord, this is 2019. 2019.
2019.
2019.
Yes, my lord.
29. 2010.
29. 29.
22/9.
No, no. No, I think
Okay,
that's a mistake.
Nonetheless, it's after the
29th October, my
29 October.
2910.
Yes,
29th, yes.
10, which is after what we parasitic that however that even if the state aspect is considered common act was as per the there is a requirement to give reasonable opportunity under section 15. This put them but examine the record of the record partition reading the the petitioner in this case is not only the affected beneficiary but also the school managing committee and the headmaster, attorney is direct to obtain the record. This when after a week.
Let it after holidays, my lord.
My lord, the holiday could not be, my lord.
I'll try.
It is from Morigaon only.
You don't want holidays.
No, my lord. Before holiday, it may be difficult.
For holiday it's difficult. It can be.
We'll try, my lord.
But last will be difficult. Difficult not for us, for you. From 15th onwards, 16th onwards, 4 5 days, 4 days.
Right.
They hardly have 1 week. That will be on the reopening on 7th November. On 7th.
Obliged.
Highly obliged.
But be an interesting.
Yes, my
Some
lord,
interpretation may be there.
I was just wondering, my lord, assuming, my lord, the school is wrong in every aspect, what is the relief that can be granted to the petitioner?
That is one aspect.
And what will happen to my provincial? That is another aspect.
But that was a matter of challenge. If on the foundation is held to be wrong, consequential action will go.
No,
We will not be too much bothered with what has happened. If we find fault with the foundation, then but at the same time, we have what the allegation was a very private kind of a arrangement. Ventures.
Yes, my lord. Obliged.
Obliged.
There.
Other side, the government law, education department. Item 17.
Passport. Manifest.
17.
17.
Talam.
Passport. We'll try to remove that on it.
Short date may be given, Lordship. Next week. Praying for fixing a date.
Next week.
Next week.
Have you reduced matter?
Otherwise, Your Lordship, we have received the instruction on the.
No, not today. File has already gone.
It is relating to my name not appear in the dice code.
No, we
That's
can
after
we can
public
take
order.
it out of control. File has already gone. Not possible. We'll try to give her that. And
Next week, Lordship.
yes, next.
My name may be shown.
Yes, yes.
Obliged.
Remove that on the non-applicant.
May I please, Your Lordship, can I mention one matter? Item number 42 of supplementary list here. Lordship. That is bench one matter, civil bench one matter, Lordship. So other side, I have already informed. Can it be fixed in immediately after vacation, Your Lordship? Fixing any date?
So, seven matter.
Lordship. Immediately after vacation, Lordship.
Must have been assigned. What is it? Full matters are assigned. Separate. Number. This court has been apprised by its chair
Appellant, Lordship.
that subject matter is bench of raised to this court appropriate.
Lordship. Fixing any date, Lordship.
We're not.
Lordship.
Sorry, madam, doing the other court matter, matter is followed.
No problem. 16 years goes for the government.
Yeah.
Department 16.
This is regarding matter that is that provincialization of language the teachers matter in schools, my lord.
Can you take for final disposal?
I think my lord, it is up to your lordship, subject to your.
Can you both
SSC
sides
also
are
will be required. It must also be required.
Yes.
SSC already filed a
Shall
video.
be there.
SSM Madam Dass
16.
SSM name is
Otherwise, we have filed an affidavit.
if the Senate councils are ready, we don't mind taking up for disposal. Today is Thursday, man for disposal matter.
Okay, two matter they have the line.
Take up.
Don't have to brief for what? Who? As voter. Where is? Can fix it on Tuesday next. Tuesday, but ask your colleague to appear.
If two money is possible, or if she is there, I do not know.
No, she is not. She is not appearing. Some other concept.
I leave to your lordship, madam. Only matter very urgent otherwise.
We can have it at 12. No problem. Is Mr. Bora is he aware of that?
Yes, sir.
Call him after a while.
At 2.
Yes. Time.
Better madam, time at 2.
At 2.
Obliged.
Council for Assam University, Mr. S.C. Kali, the state, your lordship. Sorry, your lordship. I pray after some time.
What would matter? That will be
Admissions.
admission. After some, will he come after some time?
Yes.
Maybe after 2 o'clock.
Okay, Lordship.
After
Obliged, Lordship.
Made with your lordship. This relating to my lord appointment of principal. Selection and appointment of principal. The petitioner is presently working as postgraduate teacher, my lord, subject teacher, in my lord, Kolaygaon
Take-
Senior
take-
Secondary School.
take for finalist.
Yes, sir.
Who is for the other side?
Mainly he.
For the BTC
Yes, sir.
and other the respondent.
And the private respondent is there.
Who is for a private respondent?
He is there.
You are there?
An advertisement was issued, my lord, page 32.
Advertisement for
For appointment of principal, my lord, at page
dated
32. Dated, my lord, 12 of November 21. Yes. So there it was on serial number 14, that Kolaygaon Senior Secondary School, Kolaygaon.
serial 14.
Yes, ma'am.
Kolaygaon.
Senior Secondary School. Earlier it was junior college. Now it is, my lord, Senior Secondary School, Kolaygaon.
Yes.
The petitioner is working there, my lord.
And how many of you are there?
Beg your pardon, my lord.
How many of you are there? One petition. One petition.
Yes, ma'am.
Single petition.
Single.
Yes. He was working as what?
He is working since the beginning, my lord.
As what? The same school.
Same school, he was working as, my lord, subject teacher, because it's a earlier junior college. So only, my lord, class 11 and 12 is there.
Yes.
Not other
He was working
other
as,
classes.
working as subject teacher.
Subject.
Thereafter,
Thereafter, my lord, the while selection, my lord, it is found, my lord, that one general guideline is there, my lord.
you also applied for this post.
I also applied for the post, and my lord, and page 45, your lordship, may kindly see. The general guideline was issued, my lord, order was issued on. One minute, this is not. Is my lord.
45.
Notified, my lord. Yes,
45.
order. Yes, revised guideline for selection of principal of provincialized higher secondary school relating to awarding of marks as per new service rule 2018. Here, my lord, your lordship may kindly see where a defect lies, my lord. 2, 3. 1, my lord, that administrative serial number 2, administrative ability 3 marks. It is specifically given, my lord, award 3 marks, national award 1 mark, state award 1 mark, and district award 1 mark. In respect of national award, award should be given by Government of India. In respect of state award, award should be given by the Government of Assam, and in respect of district award, award should be given by the district administration. Secondly, my lord, ACR, serial number 3, integrity and personal marks. ACR for last 2 years preceding the year of selection. Good 1 number, very good 2, and outstanding 3. The defect lies there, my lord. The respond number 5. Respond number 5. He has been given wrongly, my lord, regarding the award mark and, my lord, ACR mark. That, my lord, by filing an affidavit as per your direction, my lord, I have filed an additional affidavit. That is in page 57, my lord. Paragraph 4, page 58. And that paragraph from 12 to that the petitioner begs to state that on 14 March 23, the present petition has listed for admission hearing and hearing took place on that day, as directed by the Honorable Court on earlier occasion that so and so to produce the relevant records on the next day. The learned counsel for BTC produced the relevant record, page 58, my lord. Record for selection process, including the select list, biodata, and the petitioner as well the respondent. The Honorable Court, after going through the records in details, pointed out some of the important points wherein the authority, while allotting of marks, has violated the existing revised guidelines dated 22/6/21. The petitioner further states that the Honorable Court, after going through the records, referred the relevant records to the counsel for BTC and the counsel for the petitioner. After going through the records, both the counsel found that the respondent 5 C so and so have been illegally allotted marks by the selection committee in violation of guidelines dated 22/6/21. He has been allotted marks 3 against ACR, although the mark given in the ACR is not as per norms and laid down in the guidelines. He has been given marks. He can be considered for next promotion. Instead of not following the guidelines, the ACR was written by the higher authority as he can be considered for next promotion. As per guidelines, remarks should have been given as below: good 1, very good 2, and outstanding 3. So within this periphery, he should have been write the comment. In case of the petitioner, in the ACR, marks has been given very good, and he has obtained 2 marks in that category. The petitioner states that in category of administrative ability and respondent has been given 1 mark and petitioner has been given 0 mark. As per guideline to measure administrative ability, award, my lord, award I have just written. Award 3 marks, national award 1 mark, state award 1 mark, district award 1 mark. Although he has been given 1 mark, that is also he is not entitled to, since he has not received any award either from Government of India, nor from Government of Assam, nor
Private
from
respondent.
private respondent. So that 1 mark is also he is not entitled to, as per the guideline.
Private respondent number
Respondent 5
did not get any award.
did not get any award as specified in the guideline. So I got 0. He should also got 0 instead of 1 mark.
Third,
Guideline dated, my lord,
1 mark.
22nd June 2021.
Administrative ability.
Yes, ma'am. Administrative.
Yes.
Second one, the petitioner has to submit that the petitioner has been allotted 16 marks and the respondent number 5 has been given 18 marks by the selection committee.
What is the total mark you have got?
I have got 16, he has got 18.
Petitioner got 16
Yes,
and R5 got 18.
yes, madam.
Now, even if we remove this 1 mark for award,
1 mark
is
plus SCR.
is about
3. No, my lord, 3 marks will go because it is not as per the guideline.
no award he did
SCR.
not get.
Error also not get.
Award he did not get. So it will be reduced by 1 mark.
Yes.
So he's still at 17.
No, my lord, 3 marks will go, my lord.
Why?
As per SCR, my lord.
Why?
SCR, my lord, specifically what is to be written, that is as per guideline has to be written, good, very good, or outstanding. They have not written that. The reporting officer has written that, my lord, he can be considered, his case can be considered for next promotion.
There was no
So
gradings
good.
as such.
Beg your
There
pardon.
was no gradings given.
No, grading.
No gradings.
No gradings.
Good, outstanding, very good. Those are not there. Yes.
That's why that 3 marks will go.
Please, the Lord. My Lord, before Lordship goes into that aspect, and for we have already filed affidavit in opposition, my Lord. Respondent number 2. And Lordship, kindly take up the affidavit.
Page.
Page. Page 74.
Your R2.
R2, man.
Yes. 73, yes.
Lordship, kindly come to paragraph 3.1,
Page
page 74.
3.1,
Lordship, got it?
yes.
Before I go into this, my lord, the entire, my lord, the petition is structured on a wrong premise, my lord. But according to the petition, my lord, petitioner's assumption is that, my lord, the interview was conducted for a particular secondary school, which is not actually correct. It was an interview for the entire district of Odalgu, and merit list also is prepared on that basis. my lord. The lordship will find the statement showing the total marks awarded to the candidates for the post of principal of higher secondary school under Odalguri district at page 81. My lord, for the time being, lordship, kindly come to paragraph 3.1.
3.1, yes.
My lord, Director Vichi on 11/11/2021 for filling up the vacant post of principal in various provincialized higher secondary school and senior secondary school under Bodoland territorial region. The selection process in which the petitioner and the respondent number 5 participated was held for selection of the post of principal of 5 numbers of higher secondary and senior secondary school across the district of Odalguri district under Bodoland territorial region.
What is the name of, what is your name?
Kolaigaon
Kolaigaon
Senior
Senior.
Secondary
Your
School.
name, madam?
Serial number 14,
Ravindra.
Ravindra
So
Soikia.
then, private respondent,
Robin,
Soikia, Basanta Soikia.
a total of 22 persons participated.
just a minute. Just having a look at the Ravindra Sohori. Ravindra Sohori is the petitioner, correct?
Yes, my lord.
Basanta what?
Basanta Soikia.
R what?
R5.
Here you got 3. This year you got 3. So there were no grading.
Documented for next by my effort.
In that case, what you cannot be the fact that you no marks would be given. Some marks have to be given. But what would be the mark?
Provided it have been my adverse remark. It have been completed, not adverse. Not being an adverse remark, I'm that.
So did you get an award? 1 mark for award?
That the expert officer has gone.
No. You are appealing for 5. Did you get any award? National, state or district? Did you get it?
Not take to be the
Then 5 1 mark.
record.
We are not on record. Records may be wrong. It's up to you. You whether you have got an award, award or not, you have to say, yes, I got this award. This is my award. If you are not even sure whether you have got an award, how can you be given marks 1?
For that was project.
Award was given
in accordance with procedure, my lord.
Yes.
My lord, a total number of 22 candidates participated in the selection process, my lord, with regard to the Odalguri district. My lord. The respondent number 5 secured 18 marks, my lord, and the petitioner secured 16 marks, which were allotted as per revised guidelines for selection dated 22/6/2021. It is also pertinent to point out here that in this common selection process held against 5 schools, Sri Sarvanand Devo Sharma secured 20 marks. Lordship will get it in the consolidated statement at page 81, my lord. He stood first, my lord, securing 20 marks, and he was declared as the first candidate. And the respondent number secured 18 marks. Respondent number 5 secured 18 marks, with date of birth being 1/3/1969, was declared as the second candidate. One Dr. Shiron Nazare was declared as the third candidate, having secured 18 marks, with the date of birth being 13/4/1971. And Sri Medini Bora, who secured 17 marks, with date of birth 1/3/1966, was declared as the fourth candidate. And one Sri Jagdish Chandra Deka, having secured 17 marks, with date of birth being 22/4/1977, was declared as the fifth candidate. On the basis of the marks secured, these 5 candidates were appointed in 5 numbers of higher secondary and senior secondary school under Odalguri district. Thereafter, from consolidated statement of marks, it can be seen that after the 5th rank holder, candidate Jagadish Chandra Deka, another 5 numbers of candidates are ahead of the present petitioner, my lord, who are senior in terms of the to the petitioner in rank, superior, my lord. As such, provided the selection of the respondent number 5 is set aside, my lord, by this honorable court, even then, my lord, there are 5 numbers of candidates who are above the petitioner, my lord. Thereby, the petitioner does not even have the locus standi to prefer this instant petitioner, my lord. The respondent number 5 was appointed as the principal of Kalaigao Senior Secondary School, Odalguri, based on the marks secured by him in the selection process, and not on assumed fact that the respondent number had opted for the post of the principal of that particular school. Moreover, my lord, the petitioner has not challenged the selection process. The entire.
Let us interrupt. Petitioner got 16 marks.
Yes.
And there were 5 vacancies.
14. But as per 14
5.
school, my lord, 14 vacancies. And what as per 14 school, no? You are
For
given only
Odalguri
details
district,
of
it
it.
is 5, my lord. For
But
the entire
advertisement is-
BTC, there are 14 vacant posts, my lord,
Okay.
which were advertised in the single advertisement. And district-wise merit list was
Madam, let us store an application for your submitted percentage advertisement.
That is on record, my lord.
Then let us see the advertisement.
Advertisement is at my lord, page 32. Odalguri district, of course, 5, my lord. 5 schools were advertised. Page 32. Yes, yes, yes.
Sorry,
While applying, was it to be specified for which school you are applying for?
Kolaigaon, my lord. He was working in Kolaigaon. He has applied for Kolaigaon. There are 3 applicants in the Kolaigaon higher secondary, senior secondary. Sorry.
No, are you required to give any preference that
Yes,
you are
my lord.
applying?
School wise. Yes, my lord.
But the
School wise.
selection is held as conflict.
Selection is held on selection, but
Now,
they have to-
when you have contended that there are other candidates above selection,
Yes.
even if the respond number 5 goes,
Yes.
these candidates are the persons who have been given the offered the appointment, or there are other candidates also.
Yes. In the merit list, my lord, there are
What is the position of the petitioner?
13 above him. And
petitioner's position is, my lord.
In the
page
merit
83,
list?
page 83, my lord. Rabindra Sahaja, then my lord Basanta Kumar.
5 candidates were selected, my lord. Thereafter, 5 more candidates remain
Above her.
above her.
That is what we are trying.
And they were not, they have not been made a party, and neither first position holder, third position holder, and fourth position holder.
So that may not be very much concerned. If the last person, so, but will we get the appointment if we interfere?
Absolutely not.
Who are they? Who are above her?
Yes.
So far as Udalguri is concerned,
Just I am reading on.
Madam, you got 16 marks.
Yes, my lord.
One Sarvananda Deva Sharma got 20 marks. He's passed. Okay.
Sarvananda Devasarma got passed, securing 20 marks. Hiralal Sharma
Hiralal
got
Sharma.
16 marks.
Itu can I appointment delay? Hiralal Sharma. 50,000.
Jagadish Chandra Deka, he got 17 marks. Medini,
Hiralal got same marks.
Yes.
when it comes to same mark, my lord, date of birth is found. If he is senior in terms of the date of birth, my lord, he is preferred.
Let us comment.
It is there in the minute, my lord.
Okay, 17, 13, 16.
Jagadish Chandra Deka. Seventeen, 16 to Horilal Sharma. Horilal Sharma का appointment deciding. Horilal Sharma को deciding appointment. Medini Bora.
Who are the
17.
who are the 5% who have been given appointment to Udalguri district?
My lord, I am coming,
Serial number?
my lord. So, one series Sarvananda Rekha, my lord, who stood fast. Then
Yes, this is what
Jagadish.
we
Jagadish
respondent
Chandra.
number 5 just taken,
serial number,
and Dr. Shiran Nazari,
serial number 2, third, serial number
who is the respondent number 5. Third,
4, 5. Saran Najari. 4 and
third
5.
number, third.
4 and 5.
4 and 5 is Medini Bora,
Medini Bora.
17. Father. No? But
But there are many other candidates getting 70 marks.
even 16 marks getting having date of birth earlier than
Even if we avoid that,
record, my lord.
even if we avoid that controversy, date of birth, with 70 marks we have candidates. 70.
Yes, my lord. 7 marks candidate, they have not been appointed.
in minus it is clearly written. Ma'am. There is
But why did you select respond number 5? Only because he is in the school, in your school. Madam,
Yes, my lord.
why have you selected
He
respond
was,
number 5?
he was working in some other.
No,
schools, my
because
lord.
he is been appointed in your school. That is why perhaps. Because he is appointed as principal in your school. That is the reason you have added him a party.
Yes, my lord.
For selection, I think there were other parties also.
the wrong.
Some later on, my lord. Earlier, the record was also placed. Full-time hearing was taken place. That time, my lord, it has not come, my lord. Only the record of this
So
school,
the different
particular
issue,
school
my
was.
lord, when the issue came up, my lord, then we were directed to file affidavit.
And hearing was completed.
And if
This line
we have
never placed.
we have
earlier.
filed
There is,
affidavit,
Mr. Abha, there is one thing.
my lord.
Triumph SI case appears to be made out, but we may not be able to grant any relief, or rather you will not get the fruits of the litigation.
Yes, my lord.
That is the
After getting this affidavit, I'm realizing that because earlier, my lord, when the hearing was completed and order was to be passed, my lord, that time, my lord, it was reserved for necessary orders. But my lord, anyway, I came out.
The things
because of
beyond
the
our
my lord.
control, my lord, to be
So, my lord, the record was placed. Then, my lord, it was comparison given of me and him, my lord. Respond number 5. Then, my lord, this is the pen.
right
Now
from
also,
the
my lord, if I don't get, but he cannot get his work has to go.
right
Marks
from
has to
the
go.
beginning, we are
Marks has to go.
consistently saying that
Yes,
it is
academically,
a misunderstanding.
he is much poor. Academically, his marks are
Correct.
much poor. No deputation for B.Ed. And my lord, poor enrollment. My school is having, my lord, 1100 students. And the school he has come from, my lord, only 50 students. Only 50 students. So, leadership
These
quality.
are the
also.
findings of
But
the
my lord,
council level selection board. my
I
lord.
may not get, my lord, the
The board decision, we cannot enter into this.
because
After
this is filed, my lord,
verification and
very
scrutiny,
lately, my lord. It was filed on my
there
lord.
are competent members, including
June 22.
let her submit.
Okay.
Yes, it is filed, my lord, on 21st of June 23. So, my lord, so my lord, not that, no, it is later than that, my lord. So, my lord, after getting this affidavit, my lord, recently it is filed. So, my lord, after getting this, I am also confused. But, my lord, my serial number has been placed over him. And if he, my lord, his mark will go. I'll not be benefited, but his mark will go. And, my lord, they have to appoint another person as per seriality, or, my lord, whatever it is. Bueno, de pronto, pele kolaiga, edita nam kena. Kolaiga, siapa siapa tanam. Persen ke respon, ya gimana sih? Iya itu sama itu persen.
Yes, Mr.
But
But I was about but the conduct of the petition itself has been filed after a very limited stage after my date of appointment, after I received my
Your appointment can challenge.
no application has been preferred under the right to it. She herself has participated in the selection process. Aware that so many persons have participated, that being aware that entire fact has been concealed,
Which one?
that the joint selection process. She has tried to project the case that is just the selection process of the principal of Kalaigao, because she herself is teaching that particular. I have been selected, I have been allotted the marks, I have been placed at number 2, and that's why I have been placed in this particular school. I have been appointed there. Not my fault. The challenge should have been against someone else's selection. Thereby, the locus itself is not there. Challenge this entire appointment process. The selection process has not been challenged. See my appointment order. Now, the regarding maintainability, my learned friend, he has raised because aware of the fact has come to the record.
Records are also here in this court. Lordship may even examine the record. Entire process is transparent, man.
Just it.
Record. May go first into the minus of the meeting at page 5. Minus the council level selection committee.
Yes.
Page 5, my lord. Lordship may kindly come to resolution number 3. Resolution number 2. It is resolved that 14 numbers of candidates, Kokrajhar district 1, Baksa district 8, Odalguri district 5, as per list enclosed in Annexure 1, 2, and 3, are selected on merit basis for appointment as principals in provincialized higher secondary school against the advertised post as per mark obtained by the candidate under the Rule 12, subsection 4 of the Assam Secondary Education Provincialized School Rules 2018. Resolution number 1. Council level selection board has properly verified district-wise interview sheet of the candidate applied for the post of principal of provincialized higher secondary schools in the district of Kokrajhar, Baksa, and district, and have decided to select the candidate purely on merit basis as per Gov order notification stipulated above. In case of candidates who have obtained equal marks during the process of scrutiny, the board has decided to select the candidate seniority wise on the basis of date of birth. Accordingly, this was done.
How can mark for award to private award? He has not got an award.
Private students award to rate.
National award, district award, state award. One mark is
Those were provided according to the norms method.
no,
There
no.
is
What
no-
is the award he has got? What is the objective? Do you have the record?
Yes, my lord.
What record?
District 56 Research Celebration Committee, Odalguri District, please to confer the honor of good teacher to you for your outstanding contribution.
What's your name? Verified.
Perfect.
Is there in the record, ma'am.
Award. Teacher is good teacher or yes, got madam. There's a district award.
District award from the my lord Deputy Commissioner.
From the BTC.
From BTC.
According to the norm.
On my
So if there was objective error, then perhaps that's why test. Without there being an award, how can you give mark?
Yes. Seems on.
yes, ma'am. But my lord, regarding CR, my lord, SCR mark.
Yes. Yes, anything else?
Everything is there on the record, ma'am. But to re-verify the
We'll reserve this. We have
But school-wise,
we'll retain the record.
yes.
School-wise seniority, my lord. Lordship may, because they have preference given, my lord, to as school-wise.
Heard. Like heard the or Bharat for training council, secondary education. And P. Bharat, Senate Council for the Private Fund. Rabha has also placed on record a place can copy of this report, which have been here is
Highly obliged.
I'm like, particular school. And in the present school, my lord, the petitioner is working. Here, my lord, only 2 persons, because another one was there lady, Razia Khatun. She is going to retire. So, my lord, the contest is between, my lord, the respondent number 5 and petitioner. And if necessary, I can file an additional affidavit, my lord. If you are to keep it. Only, my lord, your lordship will kindly see the application. Application against particular school. All applications are against particular school. So in this particular school, 2 persons.
your counterpart.
I've informed Rabham.
And Mr.
He-
Bharadwaj,
He is another court, my lord. And he will come after some time. I will inform him and
also will check to verify.
yes, ma'am. Oblige, ma'am.
Lordship, I have received some instruction from the university based on the record.
Hmm.
Lordship, now lateral admission cannot be given because there is no statutory provision to that. Earlier, university used to fill up the seat by Bachelor of Science and other. Now there is no rule and there is no statutory requirement that is there.
Now, are you giving them
No,
admission?
there is no statutory provision to. The Lordship, the instruction is clearly stated. There is no provision of lateral entry of graduate of bachelor POC program in BTech graduate. Hence, the university stopped further processing of the matter for admission as the lateral entry is not supported by any statutory provision.
What about the 6 seats? Now, nobody has been given.
No, Lordship, from that, from other streams they have given, but
No, from lateral.
Lordship,
yes, Lordship, it is stopped.
6 vacancies were there.
Yes.
seats are vacant. Lordship,
Anyone given from there?
No.
No lateral, not even a single.
No, Lordship, from that it is, now it is, the instruction is clear, Lord.
Can you file an
Yeah, I'll file it.
Lordship, with utmost humility, Lordship, I beg to submit a few points, Lordship. Lordship, the prospectus that is annexed at page number 43, Lordship.
So they have admitted it earlier.
Lo-
round,
Lordship, even
they-
that year also, Lordship.
This year also, Lordship, we contacted, when we came to know that is it, all these may given.
You filed the affidavit.
Yes, Lord, I filed.
Lordship, one prayer, Lordship. Lordship, as the classes has already started, Lordship. Lordship, eventually, if they're given opportunity of admissions, Lordship, they will not match up with their classmates, Lordship. So, Lordship, kindly consider the interim prayer, Lordship.
They have not been for even a single one. Out of the
Lordship,
6 vacancies,
Lordship, only 4 people have appeared in the entrance test, Lordship. 2 of them not turned out for entrance test, Lordship. Only 2 appeared on the Lordship. And these are the 2 petitioners, Lordship.
the
Lordship,
council something which is not permitted by law. That's
Lordship,
for their version.
Lordship,
Can the court ask them to do something?
Lordship may kindly, Lordship, peruse Annexure 11, Lordship, for a minute, Lordship. With utmost humility and folded hands, Lordship. Lordship, as the matter is very serious, Lordship. And
Page?
page 64, Lordship. Lordship, this is an admission notice, Lordship, for the academic sessions of 2020-21, Lordship. And in that, you may find, Lordship, merit list of eligible candidates, Lordship, for 3-year BTech lateral entry admission to agriculture engineering, Lordship. Lordship, the person which found place at serial number 3, Mominullah Borbuya, Lordship. Lordship, I have his certificates regarding Bachelor of Vocation, Lordship. He has passed Bachelor of Vocations, Lordship. He has given admissions through lateral entry, Lordship. How can a similarly situated candidates cannot be given opportunity of admissions to Lordship BTech lateral entry, Lordship?
Council, they're admitting.
Yes, Lordship. Lordship,
They're admitting. You don't have to face this. They're already admitted that on earlier occasions, something has happened, some aberrations has happened. But once realizing the law, they are fixed the right course.
But
Can we say that no, you did the same mistake?
Lordship, they have actually initiated the process, Lordship. Now, under the guise of this,
Is there any estoppel in law?
Lordship, the petitioners have legitimate
The process has been initiated, something is given. Is there any estoppel in law?
Lordship, the petitioners under the legitimate expectations, Lordship, they have not applied anywhere.
Expectation has to be read along with estoppel. Or can there be, is there any estoppel?
Lordship, now who would compensate these petitioners, Lordship? They have lost 1 year of their academic career if they are not given opportunity, Lordship. Lordship,
You filed a suit for compensation.
Lordship,
Decided on its own merit.
Lordship, Lordship, consider the matter on humanitarian grounds, Lordship.
Not a question of humanitarian ground. If something is permissible under the law, we'll definitely.
Lordship, if statutory approval is not with their Lordship, had there been no statutory approval, how they allow this course to run in these all
What do you want now today?
Lordship?
What do you want today?
Lordship, these petitioners should be given opportunity, at least provisional admissions for now, Lordship.
We rejected. Heard the Sri N.J. Chaudhary, Senate Council.
N.A. Mazharbuya, Lordship.
N.A. Mazharbuya, Senate Council.
Lordship, then let them file the affidavit.
Sorry, you have taken much time of the court.
Lordship,
Also heard Sri S.C. Kail, Senate Council, hearing for the Assam University. Para. The fact predicted is that the petitioners had passed the Bachelor of Vocation within bracket B.O. from the Assam University Silchar. The state university offers a course for BTech within bracket lateral in agricultural engineering. And in terms of the prospectus, the petitioners had applied for the same course. However, after participation in selection process, the result of the same has not been declared. The petitioners had earlier approached this court by filing WP 56 of 2023, when this court had directed the Learned Training Council of the Assam University send a list of selected candidates for admission into BTech lateral. The university, however, informed this court that the candidatures of the petitioners were rejected, and according to secondary petition filed.
Lordship, may kindly given us one opportunity, Lordship.
PSC Senate Council for the university has produced a copy of the instruction received by mail, as per which there is no, as per which, comma, though the university has considered of conducting admission tests this year for lateral and comma, on verification, it came to light that there is no statutory provision for lateral entry of BE for graduate to BTech course, and the AIC norm only permits limited course for lateral entry in BTech courses, and BFOC is not one amongst them. Para- Their instructions are required to be placed on record by way of that written by 4 weeks. The Union of India, Union of India, this is still the court. K Gokul. K Gokul. You're a K Gokul? K Gokul. Then it's just note on behalf of number 1, whereas SC Kyle, the understanding of the University, except on behalf of 2 to 5. The other respondent number 5. That extra copy is served upon the the council by tomorrow. There are the council for the based interim order for grant of provisional. However, consider the written instruction that there is no provision for admitting candidates, admitting for graduate candidates for BTech within the lateral course from the interim period. Much
Obliged, Lordship.
May I pleases you, Lordship? I tried to inform as Flora, your Lordship,
Yeah.
but he was not here, your Lordship. He left the court, your Lordship. So kindly, a date may be fixed Tuesday.
Third courage of the council for the this court, however, has been informed that SS would be represented by the as one of the understanding council, who, however, is not present. As requested on Tuesday.
Only matter, everything exchange, everything complete matter. And obliged.
Keep your best.
Item 6. Yes. Higher education.
Let me hear it. It is Vitali Bordolo. Here, Malat, the last time it was directed the council of the principal, Malat, governing body, Malat, to produce the record.
Who is for the governing body?
Malat, I have been informed by him, Malat, he has difficulty for today. Some other day he will.
Who's
some this Gogoi, J Gogoi.
Bora.
Jesse Gogoi, Malat.
We'll have some other days.
Lord.
Monday?
Lord.
Siddha? Yes. Monday? Third. Whereas as the Standing on priority. Yeah, not standing on priority. Anyone, Madam, here for the governing board is represented by this who is reported to have some this on Monday. Lord. Okay.
Yeah.
Yes.
Compassionate appointment, my lord. Last occasion, my lord, the department submitted that review read appeal is pending.
But balance period. Is it balance period, Mr. Sheikh?
My lord.
Balance period.
Balance period, sir.
Yes, my lord, balance the year.
Not decided as yet.
Not
Okay, adjourn for
my lord.
the subject matter involved is with regard the introduction of a minimum balance period for consideration a case for appointment on commission. Court has been apprised that the present court on the list of the court. However, if any decision is rendered in the meantime, the learned council are at liberty to make a mention about
Obliged, my lord. 24 is same, my lord. 24, my lord. Next item, my lord. Similar, my lord. Obliged, my lord.
council. Hello. Did you inform the health department?
Yes. He was there, madam. Just now he was there.
Who was there?
Buddha.
Okay, let him come there. You can start if he's around. Is he there? Coming. Okay. You can start?
Yes. My lord, here, my lordship will come to the page number 32, my lord. This is a notice, educational notice, my lord.
Gogoi, just have with the copy.
The counseling is about on 30th of September. All seats have been filled up. More particularly, my lord, tea garden, my lord.
The deadline is 30th.
Lordship, that
while you had mentioned, we had said Supreme Court in a number of cases has said after 30th there is no question of any admission.
Yes, my lord, that's true, my lord. Only here, my lord, in my case, my lord, totally in arbitrariness and illegally, in my place, my name was reflected in the Kokradhar Medical.
When was it done?
My lord, that was the select list was published on 29th of September, and I was supposed to join there in the Kokradhar College. And on 29 itself, at about 10 p.m.
How do we overcome the embargo of Supreme Court? 30th of September.
Now, my lord, there is a order.
What is the case? Midul what? What was the name?
Middle.
Middledhar.
2005 to SCC.
Middledhar.
Well, since I have also enclosed some of the
on top
honorable.
of that,
Have you read Middledhar? See the embargo. The date has been fixed. It's not in 1 year. It's a general. It's a principle laid down that after 30th of September, no admission.
No.
By the court.
No. Since my lord, there has been totally illegality, my lord. In my place, how this
You can file for compensation.
how this general category has been appointed in my place, my lord. All along,
Mr. Chetty, what relief can we give? Tell us. In view of the, just show him. Miruldhar.
Yes.
Have you got Miruldhar?
Well,
Just have that your senior colleague. Because see, in this type of cases, if we did not pass any interim orders, you will not have any relief. Even if you have a good case, unless we protect you by an interim order, you will not get anything tomorrow. And here is a case where we cannot pass an interim.
But fact remains, my lord, only for lordship's information that on a tip, my lord, I have been told to report in the Kokrajhar Medical College. When I went, then on 29th,
Can you take any instructions
my lordship may kindly turn to page 53
of the
of the report. In fact, one candidate, that is Seema Rani Dar, they approached the honorable court on the plea that, my lord, the non-familiar certificate for OBC, my lord, or ex-Tea Garden,
page
53.
53?
Yes, it starts from page 50, annexure N.
Yes.
Now, relevant lordship you will find
7.
page 53, para 6.
Para?
Para 6. Paragraph 6, my lord.
Yes.
In view of the above, the rejection of the application of the daughter of the petitioner for non-familiar certificate by order dated 18/9/2023 is set aside, and the matter is remanded back to the Deputy Commissioner Sonitpur to issue an appropriate non-familiar certificate to the candidate, namely Sayona Kashyap, by taking note that only one of the parents is a working parent and she is working in category 3 post, and therefore under the law is entitled to a non-familiar certificate. The certificate be issued in the course of the day itself, in as far as it is a matter of admission to a medical college, where the last date of admission would be 30/9/2023, that is tomorrow. The daughter of the petitioner is also directed to immediately approach the Director of Medical Education for doing the necessary formalities. Director of Medical Education to take note that there is already a declaration by the court as regards the entitlement of the daughter of the petitioner for a non-familiar certificate, and
Yes,
therefore,
Even
so
if
now,
there is
my lord, in order
delay,
to accommodate her, my lord, because this petitioner, that is Seema Rani Das, no, my lord, Kashyap, Sayona Kashyap, he is higher in rank than the present petitioner. Petitioner was otherwise he was given an admission, my lord, but he is the last candidate under that category. To accommodate her, his admission is taken.
There were 4 rounds, my lord. First, counseling.
and this Kashyap, her marks is more than the
Yes, rank is higher than the petitioner.
That is in general.
only because of the familiar
Certificate. Yes, that is the situation.
And my lord, here only at the time of this, the booklet itself says he or she cannot change the category, my lord, at the last stage. That guidelines is there, my lord. The first
No, there
guideline.
is no question of change of category. They were not accepting the non-familiar certificate.
My lord.
Court says that it's not proper.
Yeah.
DC has to give an opinion, and
No,
if
my
you are
lord.
aggrieved by consideration of her case, you have to file something
Yeah,
here.
well, not
As,
my lord.
as per this guidelines, my lord, just I'm for your lordship's information, my lord, I'm just reading. The guidelines, no, number 1 guideline, no correction facility, including category change, will be given at any
Who has
stage
changed the category?
after the registration.
Who has changed the category?
She has changed.
Where?
Category from she all along appeared as general, my lord. Registered as general category all along, and the Delhi High Court this reference has the judgment has said that once either OBC category or whatever it is, if she registered her name as general category, she cannot come back. That she cannot change at the last stage.
We do not know what is her status. You are only on your averment.
Well,
Her matter has been adjudicated by a court. Can the court
No.
can we say something
Here,
against it?
here, Lordship, only my prayer, since this honorable court did not say anything about the changing of category, man. Only non-familiar, yes, that part Lordship was pleased to direct. And if she is found on merit, her case may be considered. Merit means, my lord, she was all along in the general category. And when she failed in the general category, now switch off to the OBC NCL. Now at the time of registration, Here, what it says, my lord. The second,
You see paragraph 2 at page 51. What you are stating is directly contrary to what is in paragraph 2. These are recording by the court at page 51.
the daughter of the petitioner, Sayana Kashyap, had offered her candidature for a seat in the first year MBBS course for the year 2023 in the state of Assam under OBC category. My lord, OBC.
Did familiar, non-familiar was the only
No, my lord.
dispute. It's
Yeah.
not a question of general to OBC.
Only OBC cannot, my lord. Only OBC
You
cannot,
can
my
issue
lord.
notice, nothing else. And there is an order of this court. Unless that has to be reviewed or higher bench says something.
No,
No, concept.
Lordship, have a look at page.
We have already had a look.
At page
We have
60,
had a look.
58, my lord.
Conflict for the petition. Who has filed this petition with regard to medical, with regard to admission in the MBBS.
First year MBBS.
Yes. In the MBBS. Full stop. It is the case of the petitioner that he had applied in the National Eligibility Entrance Test within bracket herein after N bracket close within bracket UG 202 and had secured 430 marks out of 720 in the category of OBC non-creamy layer. The petitioner was also selected for admission by directors dated 28/9/2023 and was asked to report to the Kokrajhar Medical College. However, it submitted that pursuant to an order dated 29/9/2020 passed by this court WP 5730 of 2020, the admission notice of the petitioner has been cancelled and in his place, the respondent number 5 has been allowed to be admitted. Full stop. It is stated that the respondent number 5 had applied as a general category and had changed her category during the course of during process of admission, which is not permissible. B. Gogoi, standing counsel from Health and Family Welfare. This is Health or DME?
Health and Family Welfare.
Health and Family Welfare Department, however, submit at the outset that as per the law laid down by the Honorable Supreme Court in the case of Mridul
Pilot.
reported in
2005 FCC page 65.
The admission in MBBS are to be the last date for admission into MBBS has been fixed on 30th of September, which is not to be extended. So, he also submits that the impugned action is a result has been taken in compliance of a direction of an order date 29/9 of this court passed WP 5730 of 2020. He further submits that the projection made that the respondent number 5 who has been accommodated in case of the petition that she belongs a general category and she belongs to the general category is prima facie incorrect, which would appear from the order of this court itself, wherein the subject matter was with regard to validity of the non-creamy layer set. Submit that unless the said order is either reviewed or interfered with by a higher court, this petition itself could not be made. That is that notice petitionable on 7th of November.
My lord,
I appear for 1, 2, and
can it be before puja, my lord? Otherwise, lordship may before puja it may be disposed of. Otherwise, again he will be under expectation, my lord. So
Before puja, last week will be a motion.
no, this way, that way, my lord.
We are having under evening day, 6th we are evening, 7th we are 7th. 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 Three co-children, 10 contract.
1, 2, and 2, 3.
Union of India, anyone? Go. Accept notice for on behalf of as the Union of that extra copy of the written served upon the learned council for the respondent by tomorrow. That steps be taken for service of notice upon response number 5 registered with steps by
My lord, any appointment, any admission, my lord, will be outcome of the retreat. Otherwise, my lord,
After
nothing will
30th, my lord,
nothing
this
will
is,
remain,
my
my
lord.
lord.
No release.
Otherwise, nothing will remain, my lord.
that whether we make that observation or not, if you make out a case, it will go. But after 30th, it's very difficult.
Otherwise, my lord,
She will try to dispose of the matter of the next.
otherwise nothing will remain, my lord. Because the again semester will start and nothing will happen. My lord.
Classes have started from 1st of September.
The Gokoi has further informed that on an interstate match, the response number 5 has secured more marks than
Only for your lordship, my lord. I'm not saying anything. My lord. Where Delhi High Court has said that earlier the petitioner was in OBC,
there is
but
no change in
it
the
has not been at the time of registration or form fill up, my lord. She has put the general, my lord. So having been OBC, now after
this is factually incorrect. The court has recorded he applied as OBC. He only this was with the non-criminal certificate.
my lord, only
Not apply as general.
here also I'm for your lordship. I'm not saying anything, my lord. For your lordship information, my lord. Here
But
also,
order that-
lordship. Unless having the NCL, OBC, my lord, cannot be accepted.
My lord, the petitioner was working as my lord in charge principal of Tharaskat College. Yes, my lord, her appointment order.
Yes, where is your affidavit?
I will file affidavit, my lord.
My lord, actually, my lord, that affidavit, my lord, issue is not related to that, my lord, whether appointment of regular principal or not. That is, my lord, not the issue here. Your lordship, can you see page 33?
No, the last they were directed to file an affidavit.
Instruction has been received, my lord. As in terms of last order, my lord.
And what the content in the affidavit that is
In terms
reflected
of last order, instruction has been received, my lord.
If your lordship kindly see the last one, that 31st August order.
not 31st or 99 order.
Yes, but the issue
99
is
order
discussed
is
here.
by way of filing affidavit in the matter of the next day. Government is to shall apprise both the names of the colleges considered as further in the affidavit. Also apprise the steps taken by the authority regarding section of
But that
what is
is
on
not
record.
remotely not related with my case, mine. Because I am aggrieved, my lord, because
These are,
Sure.
these are part of the orders. How can you
yes,
say-
my lord, if your lordship kindly see a 31st order, my lord. 31st August,
And this order to be reviewed.
that is a manner instruction, they were last second.
Moreover, my lord, the
Immediately their
petitioner-
instruction because
petitioner-
finance is also involved.
the petitioner.
You file it soon.
I will file.
Third, and second, and council of the petition. Three, as the training council had it taken submit that in terms of the order 99 have been received. Full stop. He accordingly pays for and is done 3 weeks time file affidavit. We fix the date.
A date, yes,
Based on 14th of November,
14th of November,
Wednesday,
oblige,
Tuesday.
Tuesday, oblige.
May I please your lordship? Lordship kindly see order dated 21/8/2023. Elementary education time, I'll affidavit lordship.
Filed or not?
Your lordship, instruction awaited, your lordship,
And
on
what
behalf
about
of
the-
SSC.
What about elementary education?
And
Elementary, who is there? Elementary. Mr. Tisti. The front. 3400.
Sometime may be given, someone else appearing. So that they accept.
Both the learned council for the learned standing council, elementary education department, as well as SS pray for and are granted 3 weeks time to file affidavit.
It's not only fix a date. Second week of November.
As paid for list on 15th of November.
November. Deeply objects.
Please, well, this is a matter where the university was supposed to file a detailed affidavit.
Which
Well, the
university?
matter, this is the second round of litigation.
Which university?
Assam University. My lord, in fact, they were supposed to file it on the 30th. We were supposed to file on the 2nd, and there was an interim order. One of my information from Mr. Kyle is that they are yet to file an affidavit. Well, they'll be seeking some time. Well, let this matter be taken up after the vacation, because we need to file a reply also.
We are going to file affidavit tomorrow, your lordship. So, my priority matter be taken before vacation.
No, no. Because
regarding the
I'll be on
recruitment
leave.
process.
I have already informed my learned friends, senior. I'll be on leave.
What is the
Well, this is a matter where the entire selection recruitment process has been done in violation of the Supreme Court's order on reservation. But what they have done, they have followed a vacancy-based reservation, which is not in vogue. And they have started de-reserving all the posts of assistant professors, leading to total chaos. On the first round of litigation, your lordship intervened, and there's an order.
There are reserved category candidates.
They are reserved
No,
category.
there are available reserved category candidates.
Definitely, we have given a chart. And that was the reason the learned single judge put an interim order on it, stating that you show us what are the roster points, what are the violations. Because on the earlier occasion, when this matter came up before lordship on 14/6/2023, on the assurance of the council of the university, they said that we'll comply with the reservation policy. And that was within 3 months I had to come. again. Well, this is a serious violation.
And who for the UGC?
Uh,
And UGC is there.
UGC basically, Mr. Agarwal appeared. They don't have any, I don't have any.
You have any role in the matter?
But by tomorrow, we'll file your lordship. So the mayor pray before vacation.
Before vacation it may not be possible.
Well, look, I have already taken the, I don't understand.
After vacation.
Yes, we are ready with the case. First,
Then we'll make an observation that he'll file his rejoinder before the next.
yes.
Third, he does. Learned council for the petition. Decca for assignment, however, submit that the affidavit in opposition is ready and will be filed within a day or two. We have also some urgency as there is an interim order in operation. Please, the matter is accordingly adjourned to enable filing of written opposition to be listed on 8th of November. By which time,
No, let it be on 9 because
9th,
it will
9th
be
of
a
November.
hearing. They want a full-fledged hearing.
9th of November, by which time, rejoinder my pen shall also be filed.
The interim order passed.
Sir, interim order passed earlier. Continue to the next day.
God bless.
Made vigilant. My lord, the issue involved in this case is whether, my lord, in what circumstance or situation a second inquiry is permissible. If your lordship kindly takes the writ petition, my lord. Yes. Pani bottle, pani.
You're going for a disposal?
Yes, sir. Well, for the purpose of the present case, there are some facts which may not be relevant. If your lordship could kindly come to page 24, that is the show cause notice.
24.
Yes.
What do you do?
I'm an APS officer, my lord. Presently, I am working as Deputy Superintendent of Police.
General APS.
Yes.
Yep.
My lord will kindly come to page 26.
24 years, sir.
24 is show cause starts, my lord. The statement of allegation is at 26.
5th of September.
Yes. 2018.
And this is the initial show cause.
Yes.
Which page you want?
Page 26, my lord.
Statement of allegation.
Yes.
Yes.
That while Bhaskar Oza was posted as Deputy Superintendent of Police Headquarters, Dhubri, a case by Dhubri PS case number so-and-so under section so-and-so was registered against Abu Anis Aftab Momin, Principal Hudurhat Dharamsala Higher Secondary School, and the case was endorsed to him for investigation. Accordingly, Abu Anis Aftab Momin, accused to the case, was arrested and forwarded to judicial custody on 23/5/18. During investigation of the case, Ariful Islam, brother of Abu Anis, appeared before him and requested to send the case diary of the case to the Honorable Court in time for bail matter. He refused to do the same. Instead, he demanded 1 lakh rupees as a bribe from Ariful Islam, and then Ariful Islam agreed to pay the demanded amount. Later on, Ariful Islam paid 60,000 only by cash and handed over to him at his office chamber. Thereafter, as per his direction, Sri Ariful Islam handed over 25,000 to his residential orderly, namely Krishnanath Homeguard, on 4/6/2018, which was also video recorded by Sri Ariful Islam through his mobile phone. He also demanded money from Abu Anis Aftab Ahmed after his release on bail. In this regard, Ariful Islam so-and-so submitted an FIR on 24/7/18 at Dhubri PS against him, and a case was registered by Dhubri PS case number of Prevention of Corruption Act. The case is presently under investigation. This above act amounts to gross misconduct, indiscipline, conduct, dereliction of duty on his part. These are the charges. Now, my lord, apparently the reply was filed. The disciplinary authority being not satisfied, appointed an inquiry officer. And the inquiry officer.
You contested this question.
Yes. I denied the charges, my lord.
Where?
And page 29 is the inquiry report.
29.
Yes. And I'll have your lordship's kind attention to page number 36, 35, 36 and 37. Page 35, madam.
Yes.
It's the part of the inquiry report.
Yes.
Gist of defense statement of Bhaskar Oza, the then DSP. Bhaskar Oza, the then DSP, has submitted written statement for his defense. In the statement, Bhaskar Oza stated that a case was registered against him by Dhubri PS case number so and so on the basis of an FIR lodged by Ariful Islam. Bhaskar Oza stated that he was placed under suspension by an order issued by the Additional Secretary to the Government of Assam. Subsequently, Bhaskar Oza was reinstated in service by an order dated of the Guwahati High Court in connection with WPC number so and so. Now, this is important, my lord. In his defense statement, he mentioned that during inquiry, H.G. Krishnanath, the then resident orderly, and PIP attendant Kanailal Sharma, the then cook, had deposed that an envelope was handed over to them by the complainant of Dhubri PS, and it contained a CD and not money. He also stated during cross-examination, H.G. Krishnanath had said that he had been threatened by the SP Dhubri, and the then additional SP Dhubri had compelled him, that is Krishna, to give a statement against Bhaskar Oza before the then inquiry officer. Bhaskar Oza also stated that Sri Ariful Islam and Abu Anis Aftab Momin had not given any money as bribe or money to him as stated in the FIR. Bhaskar Oza has also stated that Abu Anis Aftab Momin had not given any statement in connection with the case to Gunindra Dekadin Ayo. Sri Bhaskar Oza stated that he was a victim of interdepartmental rivalry. During cross-examination by inquiry officer, Bhaskar Oza stated that the CD received by him through H.G. Krishnanath was relevant to the case investigated by him. Sri Bhaskar Oza also stated he had gone to the CD, but it was blank. During investigation, during examination, Bhaskar Oza further stated he did not seize the said CD and not reflected in the case diary of the case. So my lord will kindly see, this is a statement emanating in cross-examination. What he said, that he has gone to the CD is blank, and that, my lord, he did not seize the CZ, neither he reported, and it was not reflected in the case diary. Having taken note of this, my lord, relevant fact, the finding is at page 37. Yes. Last para, my lord, at page 37, last but one. After careful examination of all statement of witnesses, it is proved that Sri Bhaskar Oza, the then DSP Dhubri, had received an envelope from Ariful Islam through his residential orderly Sri Krishnanath. In his defense statement, Bhaskar Oza admitted to have received an envelope but stated that it contained a CD. Further, during examination by inquiry officer, which again is wrong, my lord, inquiry officer cannot examine anybody. Further, during examination by inquiry officer authority, he stated that CD was relevant to case number so and so, which he was of which he was the investigating officer. Also, during examination, he stated that he did not report about the receipt of the CD to his supervisory officer, and neither she is not mentioned about it in the case diary of the Dhubri. So, my lord, this factum not only emerged in the inquiry, this was also taken note of by the inquiry officer, and he was found guilty. Kindly see, my lord, under the circumstances above, the charge of misconduct, undisciplined conduct, and dereliction of duty on the part of Bhaskar Oza, then DSP headquarters, has been proved. So this is the inquiry report, my lord. Now, for whatever reason, at page 38, my lord, the disciplinary authority did not agree, and my lord, the disciplinary proceeding was disposed of in favor of the writ petition. If your lordship will kindly come to page 38, last 4 subpara. Whereas having examined all statement of his witnesses, it has been found that most of page 38, my lord, last 4 small subparas, my lord.
Yes.
Whereas having examined all statement of the witnesses, it has been found that most of them have denied the charges leveled against Bhaskar Oza. In view of above, it is deemed fit by the disciplinary authority to drop the disciplinary proceeding against the officer. Now, therefore, Governor of Assam is pleased to close the departmental proceeding against the Bhaskar Oza IPS, the then Superintendent of Police Headquarters, Dhubri. Accordingly, departmental proceeding against Bhaskar Oza, the then so-and-so, is thus disposed. Now, my lord, there are ways and means. If the disciplinary authority or the appellate authority is of the view, my lord, that even this order is wrong, there are ways and means to deal with it, my lord, under the Assam Services Discipline Appeal. But the modus they have adopted, that is not correct. Now, lordships will kindly come to. And before that, if your lordship will kindly have 3rd para at page 38, kindly see where whereas the inquiry officer in his report stated charge of gross misconduct, indisciplinary conduct, and dereliction of duty on the part of have been proved. Even then, my lord. Anyway, I am not on that, my lord. Nobody challenging that order. Now, my lord, the impugn order is at page 39. First subpara. While you were posted as Deputy Superintendent of Police Headquarters, Dhubri, a case-wide Dhubri PS case under section so-and-so was registered against you. Abu Anis Aftab Momin, Principal Hudura Dharamsala, and the case was endorsed to you for investigation of the case. During investigation of the case, one Ariful Islam, there so-and-so, submitted an FIR against you alleging that you demanded money from him, and a case was registered by Dhubri PS case number so-and-so. In connection with this, a disciplinary proceeding was drawn up against you, white dated so-and-so. The said disciplinary proceeding was disposed of, white order dated so-and-so. However, the inquiry officer in his inquiry report submitted that mentioned that you in your defense statement, you admitted to have received an envelope, but you stated that it contained a CD. Further, during examination by the inquiry authority, you stated that compact CD was relevant to the case number so-and-so, of which you were the investigating officer. Also, during examination, you stated that you did not report about the receipt of the CD in the case diary of Dhubri PS case. Being a member of the discipline force and responsible police officer, you have your act above shows gross misconduct, indiscipline, and dereliction of duty. Hence, you are charged with gross misconduct, discipline, conduct, and dereliction of duty. My lord, it is a fact that this was not a part of the first charge. But nevertheless, this aspect of the matter, my lord, did emerge in the inquiry, and inquiry officer has recorded a finding of guilt. Now, having done so, and the disciplinary authority having accepted it, now is it open to the disciplinary authority to order a second inquiry on the same very subject matter? The other day I gave one example, my lord. Supposing a man against whom there is an allegation of causing grievous harm. At the time, my lord, when complaint is filed, my lord, or the FIR is filed, he is charged of having committed grievous harm. During the pendency of the case, the man might die also. Is it requirement that he will file another FIR? Police will add this section and investigate.
So your analogy may not be correct. This is a consequence of the first previous charge leading to death.
Yes.
But this appears to be an independent charge.
No, my lord, how?
You may be correct in contending that in the inquiry it emerged, the facts emerged.
Yes.
Inquiry officer took cognizance and
Yes.
said guilty, which have been not been
Accepted by the
accepted, but
disciplinary
that's a
authority.
different argument.
That,
But this analogy,
No,
perhaps,
my lord, what I'm trying to say is, now that precisely that is what had happened in this case. Now, initial
are-
charge was,
this is a subsequent development, nothing to do with the first case.
no, my lord, what I'm
The
saying
allegation
is,
is that you delayed in sending a case diary to the court,
yes,
which were
for which I demanded money.
you demanded money, and therefore that a police case was registered and a TP was also initiated.
No, my lord, why I'm saying it is a subsequent fact which emerged is, the initial allegation was part payment was made to that Krishnana.
Yes,
That envelope.
envelope.
The question is whether that, now the fact of the matter is that envelope contained a CD.
Okay.
Now that CD is, according to me, with the statement which I made, it is relevant to the inquiry, which,
No,
of which I was the investigating officer.
No, this person of yours came as a defense.
Yes.
In the inquiry that yes, there was an envelope, but it had a compact disc. I opened it, it was blank.
And I also said that I felt that it is relevant to the case.
Yeah, it's opened
But I never reported to my superior officer.
neither you reported nor it came a part of the case diary.
Yes, that.
That is it.
Yes. So the inquiry officer had the occasion to embark upon an inquiry also on that charge, though it was not part of the charge. Now, in that view of the matter, all right, my lord, let us not go by that analogy. Now, in that view of the matter, whether this second inquiry on the same very charge is part, in my humble submission, it is come. I'll place 2-3 judgments on this point.
Vidyut Borgohain.
No, there are other, my lord. Vidyut Borgohain is there, Molloy Bora is there,
KRD.
KRD. My lord, there is one more case. Vidyut Borgohain and KRD is there, my lord. I'm sorry, Molloy Bora, KRD. Apart from that, I'm relying upon 2 more judgments. So first of all, let me place the rules, my lord.
Yes, yes, sir.
Yeah. Rule 9, my lord.
64 rules.
Yes. Now, sub rule 9 of rule 9, my lord.
9.
Yes. The disciplinary authority shall, sub rule 9 of rule 9.
Yes.
The disciplinary authority shall, if it is not the inquiring authority, consider the record of inquiry and record its finding on each charge. Now, my lord, though, my lord, rule 9, sub rule 9, do not, my lord, apparently cover the dispute, the case which falls for consideration. But what clearly follows from sub rule 9 is, my lord, disciplinary authority will take action based on the inquiry report. Now, which is that inquiry report? Which is being directed by the inquiry officer, disciplinary authority itself. Now, my lord,
if
it's
not the inquiry officer,
it's not. Now, other than the KRD's case, my lord, there is no other authority on the point. KRD was a decision on rule 15 of the CCA rule. And we all know, my lord, in KRD,
71.
This is the judgment, my lord. Please listen. I think all the judgments are there in the file, my lord, last time. Here, Dev, my lord, 1971 2 SCC 102, para 12. Yes. It seems to us that Rule 15 of
Paragraph 12.
para 12, my lord. It seems to us that Rule 15 on the face of it really provides for one inquiry, but it may be possible if in a particular case there has been no proper inquiry because some serious defect has crept into the inquiry or some important witnesses were not available at the time of the inquiry or were not examined for some other reason, the disciplinary authority may ask inquiry officer to record further evidence. But there is no provision in Rule 15 for completely setting aside the previous inquiry on the ground that the report of the inquiry officer or officer does not appeal to the disciplinary authority. Disciplinary authority has enough power to reconsider the evidence itself and come to its own conclusion under Rule 9. So, my lord, what I am trying to emphasize is, my lord, be it Rule 9(9) or Rule 15 of the CCSCA rule, it really envisages one inquiry. If there are some aberration, if there are some, shortcomings, then disciplinary authority has the power, my lord, to deal with such a situation. These situations are provided in the rule. But to direct a second inquiry in respect of a charge, my lord, which is already gone into, that I think it will be too much. It will be something like, my lord, double jeopardy sort of a thing. So strictly may not be, my lord. Why should I expose myself to a double inquiry, my lord? When in one inquiry there is already a finding and finding is acted upon. Otherwise there will be no end to it. Now, my lord will kindly come to the other two judgments of the Supreme Court. 2002, 10 SCC 471, paragraph 5. Union of India versus K.D. Pandey. Or may I read 4 also, my lord?
4 and
I'll read 3, 4, and 5. My at page 472. The proceedings were initiated against has a lot of document. The proceedings were initiated against respondent number 1 in respect of 6 charges. The inquiry authority in the report made held that none of the charges stood proof. Thereafter, the Railway Board, in exercise of the power under Rule 25, examined the matter and found that 4 of the 6 charges could be substantially proved beyond doubt with the available documentary evidence, and thereafter remitted the matter for further inquiry as contemplated under Rule 25(1)(c) of the rule. On remit, the inquiry officer made a report finding respondent number 1 guilty of 4 charges. Based on that report, Railway Board dismissed the respondent number 1, which was challenged in dispute raised by him. The tribunal as well as High Court are of the view that on the same material, a fresh opinion has been furnished and it was not a case of further inquiry. Indeed, it was not noticed by the disciplinary authority that inquiry held earlier was bad or that the management or the establishment did not have the proper opportunity to lead evidence or findings were perverse. In the absence of the same, it was held that there was no justification on the part of the disciplinary authority to commence press inquiry on the same set of charges. Learned counsel for the appellant contended that in this case, the board had examined the materials on record and come to the conclusion that 4 of the 6 charges could be proved on the available material which had not been properly examined in the earlier inquiry. In fact, from the order made by the Railway Board, as well as from the part of the file where inquiry report made earlier is discussed, it is clear that specific findings have been given in respect of each of the charges after discussing the matter. And if that is so, we fail to understand as to how there could have been a remit to the inquiry authority for further inquiry. In this resulted in second inquiry and not a further inquiry on the same set of charges and materials on record. If this process is allowed, the inquiries can go on perpetually until the view of the inquiry authority is in accord with that of the disciplinary authority, and it would be an abuse of the process of law. In that view of the matter, we think that the order made by the High Court affirming the order of the tribunal is just and proper. In that view of the matter, we think that order made by the High Court affirming the order of the tribunal is just and proper, and therefore we decline to interfere with the same. The appeal is dismissed accordingly. But here in this case, there was a finding recorded in respect of each of the charges. Yet disciplinary authority took a different view. I think in this case, if the disciplinary authority would have said that on the materials placed, we are inclined to take the view that the charges are proved, instead of sending the matter to the inquiry officer for doing inquiry afresh, they could have issued a notice saying on this ground we intend to, agree. What do you say as a delinquent? Perhaps that course would have been different. We do not know how that would have been viewed by the court. But my lord, since the aspect was gone into, an inquiry officer has recorded a finding, therefore a second inquiry, in the opinion of the Honorable Supreme Court, is not permitted. This is a case which will come handy in our case. I'll respectfully submit mine. Lord, the last judgment is 2014 10 SCC 589. Vijay Shankar Pandey versus Union of India. My lord, para 26. 26 to my lord 30. After referring to my lord K.R. Deb and other cases at para 26, page 603, it can be seen from the above that the normal rule is that there can be only one inquiry. This court has also recognized the possibility of a further inquiry in certain circumstances enumerated therein. The decision, however, makes it clear that the fact that report submitted by the inquiry authority is not acceptable to the authority, it is not a ground for completely setting aside the inquiry report and ordering a second inquiry. My lord, my humble submission, subject to what your lordships may say, the preponderance of judicial view seems to be, my lord, a second inquiry is prohibited. But in certain situations, there could be a further inquiry. Not by having another inquiry officer, not by drawing up another charge. Pursuant to the same charge sheet, my lord, there is a scope for further inquiry. Something like CRPC, my lord, 173A. But there is no scope of second inquiry. That seems to be the, preponderance of the judicial.
Totally have to notice that in all these cases,
yes,
inquiry was against the delinquent. The report. The inquiry reports were in favor of the delinquent.
Yes.
Exonerating him, which was not agreed with by the disciplinary authority.
Exactly.
And he had ordered a new inquiry, which law says is prohibited.
Absolutely.
There are other methods. You can defer and you can send him another show cause that I wish to defer with this finding. What you have to, but you cannot have a fresh inquiry done on the matter.
And in my case, it is worse. In my case, my lord, the inquiry was against me. Disciplinary authority acted otherwise.
He exonerated.
He exonerated.
Now, after exoneration,
yes,
Now,
After exoneration of the same charge. That charge,
that is the crux.
Ah.
Whether is the same.
it's the same charge, my lord. I have already placed page 35 and 37, 35 and 36, where, my lord, there is a direct finding.
So these materials have evolved during the inquiry in some depositions made by your book.
Huh.
But
No,
that
in
was not
fact-
a charge.
In fact, that's why I started my argument with the, very beginning, that this particular aspect was not part of the
No,
first charge.
you have that this aspect was had not only cropped up, it was gone into it.
Gone into an and a finding was recorded.
That we have understood.
That finding is recorded. Now, once it is done, whether a second inquiry on that charge.
Here, Master, on this.
Yes. That is the case, my lord. Lordship is correct. In these cases, the inquiry reports were in favor of the delinquent. The disciplinary
spite of the
authority was not
discipline-
palatable to the disciplinary authority. They somehow
And
want
therefore,
to.
in the latest
Ah.
case,
But
they
but
say you
ra-
cannot-
but
you
railway
cannot
board.
go on until you
No,
have
my
a
lord.
favorable list.
But railway board's case is slightly different. Railway board's case is slightly different.
Which one? The other Pandey.
Yes. Other Pandey. Yes.
No, they see the last line.
Yes.
That, the Honorable Supreme Court is very
Yeah.
that is paragraph page 5.
Huh.
KD Pandey's last page, paragraph 5, last part.
Yes. Would abuse of in that view of no, my lord, it is not said.
Indeed, this resulted in second inquiry and not in a further inquiry on the same set of charges.
Huh.
If this process is allowed,
Huh.
inquiries can go on perpetually.
No, my lord. Here, my lord, from here it is not evident. But if we read para 4, my lord, the lordship will get the clear picture. Now, sorry. Examine the matter was and found that 4 out of 6 charges could be substantially proved beyond doubt with the available documentary evidence.
This was the second round.
Huh.
First round, gone. It is second on remit.
Second round.
On remit.
Yes.
On remit, the inquiry
Yes.
made a report of
Yes.
finding,
Yes.
and this was subject matter.
No, my lord, my humble submission is whether the inquiry officer has found me guilty or inquiry officer has not found me guilty, irrespective of that, if an aspect of a charge or a charge is gone into and a finding.
Let us hear.
Yes. So therefore, my lord, Molloy Bora and the other two judgment lordship, but I'll give the paragraphs, my lord. In Molloy Bora, my lord, 2015 3 GLR 152, I'm relying on para 5, 8, 15 and 20. And in my lord Bidut Borgoy, I'm relying on para 5.
Molloy Bora is 5.
Molloy Bora 5, 8, 15, 20. And Bidut Borgoy, my lord, para 5.
We'll come back to you.
My lord.
We'll come back to you.
Yes.
And first of all, it is very interesting and very unfortunate that when the inquiry officer says charges are proved, the disciplinary authority says drop the charge.
He can. He is the authority.
I mean, he can.
He
My
can. He definitely can. If
My
he has done it with a bona fide intention, which by taking the materials into record,
My lord.
the order shows that he has made it's not very elaborate order, but he has said that I have seen the materials which are against this
My lord,
delinquent.
my lord.
And I don't think that these conclusion could have been arrived at by the inquiry. That is his finding.
No, my lord,
We
he's
may not find fault with that.
My lord, in fact, I even if I find fault with that, I cannot rely on it. I'm just simply pointing out that if your lordship goes to that order at page 38, before I argue actually my case, my lord, I'm just pointing out. He says, page 38, my lord, whereas the inquiry officer in his report stated that the charges of gross
Mr.
misconduct.
Mazumdar, if you harp on this point,
I'm not harping, man.
if you harp on this point, this will lend support to Mr. Chol.
No, I'm not
Because as
harping.
if it is the same charge, one disciplinary authority.
That
thinks
is why, my lord.
But if it's the same charge, if you are considering that matter.
No, that is what I am saying, my lord.
Yes.
I'm, first of all, my lord, I'm page 38. I'm just showing, my lord, this is not part of the argument on which I'll be relying on for the purpose of countering the argument made by the petitioner. my lord.
Okay.
I am only pointing out here how the disciplinary authority has proceeded.
Yes.
Although there is no point arguing this point, I'm just pointing out, my lord, for the sake of pointing out. He says, whereas the inquiry officer in his report stated that charges of gross misconduct.
Mr. Mazumdar, again we are repeating.
My lord.
We are not going.
Let us not go. my lord.
Because if you go into this aspect,
No, my
if
lord.
you give
My-
discipline authority on a second round,
My lord.
fines fall with the earlier order, that
Absolutely.
means you're reviewing the earlier order.
Yes.
Which,
I'm not arguing that.
Okay.
Well, my submissions before your lordship are absolutely simple, clear, unambiguous, and that is the whole writ petition has been drafted and filed and argued and contended on the premise that the charges are same. My
Yes.
first submission is charges are not same at all. And that I'll point out to your lordship from the two focus notices. Well, first focus notice contained certain allegations.
Yes.
Of course, the charges are at page 24. The statement of allegations are at page 26. I will not read it further, my lord. This entire charge in the statement of allegation is based on receipt of bribe and nothing else. Now, if the disciplinary authority, my lord, this is the case I will be, my lord, relying on. If the disciplinary authority, having considered, or the employer, my lord, having considered that in respect of a particular incident, there was a demand for gratification, demand for bribe, and the charges were accordingly framed. But in course of that proceedings, if it is found out that certain the involvement of the officer was such that he actually committed misconduct under the conduct rules. And maybe further they have found that yes, although the inquiry officer has said the charges are proved, but then so far as the receipt of bribe allegation is concerned, that allegation perhaps do not stand proved. But then there are other factors which have come up in course of the disciplinary proceeding before the inquiry officer, and certain things have been recorded also by the inquiry officer, which shows that there was a dereliction of duty and there was misconduct. That is why there is a separate and different and new progress notice. And this time the charge, Lord, will kindly see what is the charge.
Okay.
Page 39, man. It's absolutely different, man.
New charge.
New charge. It is
And second show.
second show question, page 39.
We'll not say second show, we'll say fresh show.
Fresh show question. Absolutely.
Second will have
I'm
that
sorry,
second-
I'm going by their. It's a different and new inquiry based on certain allegations which form misconduct. Page 13. While you were, I'm just reading, Lord will kindly excuse me for
Yes, sir.
again reading
Please,
it.
please.
While you were posted as Deputy Superintendent of Police, a case being Dhupri PS case number so-and-so, IPC, read with section 7 of Prevention of Corruption Act 1980, was registered against the so-and-so, and the case was endorsed to you for investigation of the case. During investigation of the case, once the so-and-so of so-and-so submitted an FIR on so-and-so at Dhupri PS against you, alleging that you demanded money from him and a case was registered by Dhupri PS case number so-and-so, so-and-so. In connection with this, a departmental proceeding was drawn up against you by number so-and-so, dated so-and-so. The state departmental proceeding was disposed of on so-and-so, dated so-and-so. However, the inquiry officer, now this is important, my lord. The inquiry officer in his inquiry report submitted by so-and-so mentioned that in your defense statement, you admitted to have received an envelope, but you stated that it contained a CD compact disc. My lord, here I am pausing for a moment. The receipt of envelope is something which causing doubt in the mind of the department that there is something. Now, second part is, you stated that it contained a CD. It is your defense. You are not concerned at this stage with that. That is why, my lord, we cannot connect it with the earlier allegation. This is my first submission. Second, Lord, you kindly see, you admitted to have received an envelope, but you so further, during examination by inquiry officer, you stated that CD, compact disc was relevant to case. It is your defense. It is relevant to this. it might be relevant to the earlier one also. You were the investigating officer. Also, during the investigation, you stated that you did not report about the receipt of this CD in case of case area of so-and-so. This also shows that you did not report. Now, all these certainly form a different charge and allegations are different. Why you are doing all these things? You are relying on your defense to say that it is related to the earlier earlier allegation. No, different. Now, my submission before Lordship in response to the submission of the petitioner that two submissions basically are made, if I have understood correctly. One is charges are same, and secondly, my lord, my learned friend has made a very pertinent argument that in course of inquiry before the earlier inquiry officer, if certain allegations were dealt with and a finding has been recorded in my favor, then on the basis of those allegations, you cannot again start a new disciplinary inquiry. To this, my lord, my response is very simple. Let us take the reverse case. A charge has been framed against someone, but in course of inquiry, we find that a different charge stands proved. Can we take any action against him on that? He will say, no, there was no charge on that. You cannot take any action against me. So it is because of this, my lord, that a fresh inquiry on fresh allegations had to be initiated. Because even if certain things have come up, not the entire thing, my lord, because he could not deal with that because there was no charge. My submission before Lordship, my lord, the allegations based on which the second disciplinary proceeding has been initiated was not part of the first disciplinary proceeding initiated earlier and ended with his exoneration. It's absolutely different, my lord.
There was an old case.
My lord?
There was an old case, Michael versus Johnson 5. On this. That without a charge, you cannot punish a person.
Yes, man. I have not got that. And your lordship?
That's a well-settled proposition.
Well-settled proposition.
That's not difficult.
Unless you give an opportunity to meet the charge,
Yes.
you cannot penalize.
Yes, you cannot.
Even if it might emerge during the inquiry.
Yes. Now, my lord, let us.
Charge has to be free.
Absolutely, my lord. Lordship is absolutely correct.
Michael versus Johnson 5.
My lord, I'll just find out. My lord, I'm just repeating this again. In course of that first disciplinary proceeding, certain things have come up. Now, if we take any action against that, you will say that charges are not. You have not been given an opportunity to meet that. Incidentally, you have given certain replies, but then the proper opportunity to file a written statement of defense and to lead evidence to meet that charge has not been given. So that being the position, we had to, when we found that there are certain things based on which at least misconduct is established, now we have to give you an opportunity.
Will not amount that you are bent upon punishing him. That you could not punish him without discharge, so frame discharge. Now we'll punish.
No, my lord.
You said that without a charge we cannot penalize.
Yes.
So you have put discharge.
No, my lord, if there is an allegation of misconduct, we have to inquire. Rules say that your conduct should be above board. Now, if your conduct was not above board, and it according to us amounts to misconduct, before we punish, at least we should give an opportunity. This is how this purpose is to give you an opportunity to meet the charge. Nothing else, man. It is because of the language.
Whether the allegations have some substance.
My lord.
So you
yes,
whether the allegations have some substance. So you give one opportunity to prove the charge.
Yes, if
it's proved, not proved, go on.
Yeah. That is my submission, man. Charges are different. Maybe they emanating from the same incident, but the things different consequences are there. If there is a allegation of receipt of bribery, then it is basically on the criminal offense. Now we are on misconduct. Totally different. In fact, it has come up in course of the first inquiry, based on which we have initiated the fresh inquiry again, based on the materials that have come up in the past. That is my the judgment panel tomorrow. I'll let you.
Then it is not right.
But today I have not.
My lord will kindly take the affidavit filed by this court. Paragraph 5 at page 45.
By Deva Prasad Mitra.
Yes, by the disciplinary authority. Please come to page 45. Para 5. Please come to the last subparagraph. This is the state's perspective, my friend. Because my learned friend cannot improve upon the case by oral argument, because the disciplinary authority,
45.
page 40, because the disciplinary authority, my lord, who issued the show cause notice, the reason is indicated. Last subpara, my lord. The above,
Not seizing.
the above not seizing or reporting about CD was not a part of the allegation as per the show cause notice issued on 5/9/18. Therefore, departmental proceeding based on the show cause notice was dropped by order dated 6/8/22. However, disciplinary authority is of the view that it is necessary for a police officer to seize or report any evidence related to a case which was not done by Bhaskar Oza. Therefore, it was decided to arrive at an impartial view as to why CD was not seized and the officer, by the officer, or why he did not report about it to the supervisory officer. Accordingly, show cause notice dated was issued to Bhaskar Oza. That with regard to the statement made in paragraph 11 and 12 of the writ petition, the deponent begs to state that Rule 9 of the Assam Services Disciplinary Rule does not confer any specific power upon the disciplinary authority to hold a second inquiry into the same set of allegations which were earlier inquired into and taken into its logical length. However, show cause notice dated 8/12/22 is not based on the same set of allegations against the charged officer. Seizing or not seizing a compact CD and not reporting it to the supervisory officer were not part of the allegation in the show cause notice dated 5/9/2018. My lord, technically the affidavit is correct, but lordship will have to test it. Whether, my lord, in what we call, my lord, fairness in action, whether this sort of an action can be brought within the contours of a non-arbitrary death. Now, please come to, my lord, the page 56(1), 36(1), page 36, fourth line from the top. During cross-examination by inquiry officer, Sri Bhaskar Oza stated that the CD received by him through Home Guard A. Krishnanath was relevant to the case investigated by him. Bhaskar Oza also stated that he had gone through this CD, but it was blank. During examination, Bhaskar Oza further stated that he did not seize the said CD and not reflected in the case diary he was investigating. Now, my lord, by the charge sheet, what has been asked for, my lord? This is the question. Whether you had seized that CD, whether you have reported it to your superior authority, since you were the investigating officer of the case. He has already given his reply. My lord, why are you going by this form? Please go by the substance. In substance, was I not charged with this? What my learned friend is arguing is on the form. Form is something which does not matter. In substance, I was put a question. In fact, the allegation against me was explained to me and I understood it and I replied. That's why, my lord, in the last page, if your lordship kindly comes to page 37. Under the circumstances above, the charges of gross misconduct, undisciplined conduct, dereliction of duty on part of Bhaskar Oza, the then DSP headquarters Dhubri has been proved. Now, if I have not, informed my superior authority, if I have, my lord, not keep them posted, then it is dereliction of duty, nothing else. It is not that any additional charge has been brought, any other of any other misconduct has been sought to be brought in, which was not proved earlier. My lord, end of the day, I knew what is the allegation against me. It is I who will be aggrieved, my lord. The argument which my learned friend was trying to put from the reverse perspective, that is not for the, my lord, a state to take a plea. It is for the, delinquent to take that plea. End of the day, my lord, why in S.K. Sharma's case, now Supreme Court has said that now, end of the day, we'll have to apply the test of prejudice. Now, no prejudice has been caused to me because I was made known of the charge against me. I understood it and I reverted to it. Then a finding of guilt was recorded, which was not accepted by the disciplinary authority. That is their problem, my lord. So to say that, yes, technically this was not a part of the charge, in form, but in substance, what happened during the inquiry is, my lord, that I was confronted with this charge also. And I gave my explanation, which was not accepted by the inquiry officer. In spite of that, my lord, I was let off. That is their problem. Now, my lord, in view of the stand taken in the affidavit in paragraph 5, I don't think, my lord, a second inquiry, even under this circumstance, is permissible. Therefore, in my humble submission, my lord, the law is well settled. Second inquiry is not permissible. What is permissible is a further inquiry. And it is emanating from the same set of facts. Therefore, my lord, technically it may not be included, but it is already there. That to say, my lord, it will be an abuse of the process. In substance, everything was made known to me. I dealt with it. And the inquiry officer also dealt with it. If the Assam government thinks, my lord, the earlier Assam, even, my lord, the departmental manual also says that, my lord, if your lordship will kindly have 6.18.1, that yellow book, my lord. In Vallabhara, this departmental instructions were taken note of. 6.18.1, where the disciplinary authority on a contention raised by the person proceeded against or otherwise finds that any material irregularity has been committed and that they have caused or they cause prejudice to the person charged or such irregularities are likely to vitiate the proceeding, it will consider whether whole inquiry should be set aside or a fresh inquiry started de novo, or whether inquiry be set aside from the stage of occurrence of the irregularity and it be ordered to be started afresh from the particular stage. As far as possible, where range of justice can be served, and so long as the person proceeded against is given a reasonable opportunity of being heard, efforts should be made to resume the inquiry from the stage at which the inquiry occurred. So, my lord, even the departmental inquiry also envisages a further inquiry, not a fresh inquiry. So, therefore, I think, my lord, the law is well settled by now. And having regard to the facts, my lord, I don't think it was open for the disciplinary authority to proceed afresh by a fresh charge sheet, my lord. And secondly, my lord, in respect of this, assuming, my lord, it is a charge which can be, my lord, gone into, I have already given my stand. Now, I'll do the same thing again. The same finding which has been recorded by the inquiry officer, same will follow. I will say that yes, I did not report. So what is the outcome of this exercise? It's an abuse, my lord, of the process of law. Because the allegation was put to me, I replied, inquiry officer adjudicated. Now nothing new is going to emerge. So therefore, in my humble submission, my lord, fairness demands, my lord, my rights should be protected.
I just make one submission.
Just this Ariful Islam is the witness of the
That, my lord, that professor, that principal.
principal was different. Abu Anis Aftab
Ah.
Mumim. Ariful Islam
Was the person who delivered that, my lord, envelope.
he is witness against you.
Yes.
Read his statement at page 31. Is the statement.
Yes. Ariful Islam stated that a case was registered against one Abu Anis so-and-so neighbor. Sri Ariful Islam stated that he went to meet Bhaskar Oza, the then SP, who was IO of the case registered against Abu Anis, and told him that his brother works in the same school as Abu Anis, and that Sri Abu Anis Momin was innocent. Sri Ariful Islam stated that he had requested Bhaskar Oza to write favorably in respect of Abu Anis in the case diary so that he is granted bail. Ariful Islam stated that he recorded the statement of some public to prove the innocence of Abu Anis Aftab Momin. Ariful Islam had collected a call Bhaskar Oza on so-and-so and informed that he had a video recording to help Abu Anis. Bhaskar Oza directed Ariful Islam to hand over the same to his orderly at his residence at so-and-so. As stated by Ariful Islam, the envelope which he had given to contain the compact CD regarding evidence to prove the innocence of so-and-so. On and on, when he made Bhaskar Oza, he was told that CD was blank. In the meantime, Abu Anis Aftab Momin got bail and he did not pursue the matter further. Ariful Islam stated that on 24/7/18, Sri Kamal Chandra Sil, then OC Dhubri, came to his place and took him to PS and asked him to submit FIR against Bhaskar Oza, in which he was forced to write that Ariful gave 60,000 to Bhaskar Oza on that day, and he gave another 25,000 in envelope to Krishna, the then orderly Bhaskar Oza. Accordingly, Ariful had submitted FIR. During cross-examination, Ariful stated that the envelope which he had given to Krishna was open and that it contained a compact CD, compact disc. He also stated during cross-examination that he was forced to submit FIR against Bhaskar Oza by OC, Dhubri PS, and also Kamal Oza, Kamal Chandra Sil, mentally harassed him to file the FIR. So these are the background, my lord. That's why the disciplinary authority gave me this clean sheet. In fact, the very FIR, my lord, that's why, my lord, he stated before the inquiry officer that he is a victim of, conspiracy of the then additional SP and the OC.
I'm just showing one particular. In the second, in the fresh so-called notice of 8th of December 2022 at page 39. If your lordship goes to the second paragraph, the allegation here is basically, my lord, in the second paragraph from the bottom about 4th or 5th line, you admitted to have received an envelope, and then the second line from the bottom, you stated that you did not report about the receipt of this.
Which paragraph?
This second paragraph, my lord, is
It
big
starts
paragraph.
with
While, yes, yes. From this paragraph, my lord, I'm reading the line about 5th from bottom of this paragraph.
Yes.
You admitted to have received an envelope.
So you admitted to have been mentioned
but-
in your written statement.
Yes,
You admitted to written, but you stated that it wanted the city.
yes.
Fine.
And then, my lord, and the last but one line from this subparagraph, you stated that you did not report about the receipt of the CD indicated. So these things form at least a charge of misconduct. So these being the position, these charges are different, totally. That's myself. But that judgment I'll give tomorrow. That on charges which were not framed, no punishment can. It will be indicated.
Will examine this.
Mal.
Getting-
Diploma.
I'm deeply obliged.
May it please the Lordship. My lord, in this contempt petition, my lord, I am representing the respondent number 4, my lord. Here, my lord, we have preferred an SLP. In fact, we have preferred 2 months back, my lord, but there was some defect. The defect has been rectified, my lord, last week, and we have they have also filed a caveat. We have started a copy also, my lord. So it will be listed in the next week.
Till yesterday, as per information, we have not received any copy of
In
the
fact, the soft copy I have given to my learned friend, my lord. So
But the judgment of 18.
18. Thereafter, we have filed a review petition that was dismissed, my lord. Then we have preferred writ appeal, my lord. That was also dismissed. Now we have preferred an SLP, my lord.
What is the direction?
Direction to pay
was,
salary, my lord.
yeah, area and present salary, sorry, area salary.
My lord, mathematics, did it come after vacation, my lord?
The SLP is time card.
No, my lord. We have filed it within the time, my lord, but there was some defect, my lord, that has been rectified later on, my lord.
Will not wait it only parent filing without,
Yes, my lord, that I understand, but my lord,
or at least if it's notice also issued down to matters. PNJ council that the SLP file before the honorable court was which had come up but not done. This submission was out the last one while it of my SLP not out that mayor filed complaint could not avail for support in their delegation. Either not complaint that the matter for better orders.
Actually, the copy is a
What?
copy of the petition.
Copy I have already.
That cannot order.
Obliged.
of like
The secondary department, the affidavit, their affidavit is 11 lordship. That has not come on record.
Was not filed.
In fact, we have received the instruction, my lord. Secondary.
From the
Obliged.
Chaudhary, which matter is there? You're waiting for long, which matter? Will we clear this? Two more matters.
Made illegal. Lordship, the director not complied with lordship will get page 34 lordship.
This year appeared.
Yes, I am appearing. Yeah, instruction lordship that we have received a proposal from the district lordship. Now the verification process is going on at the directorate lordship. There's some mistake regarding the scale of the petitioner scale. So that it will take some time, lordship.
Lordship,
Yes.
The according is done to get
a date may kindly be fixed. Lordship. Husband died in 2014 lordship.
getting what? What was that?
Direction to
The
pay
access trial was not
with-
to recover and also to pay that.
lordship
But,
by
but my information is that the
3rd
appointed
January
compensation appointment that was
2022,
given to her. But though written instruction I have not received.
Are you
lordship.
That is there. So one way,
But probably is that
before we
after- a date may kindly be fixed.
31 lordship, we have complied with the order. It is in his favor lordship because
if it's your favor, it is in your favor, your client will not inform.
Yes, they are not yet inform me.
If it is against you, they will inform. Heard P.K. Charlie Leonard counsel for the petition. There are also heard the assembly Leonard counsel for the respondent who have submitted that an order has been passed on 29/5/2020 in compliance. Has been passed on 29 by the Department
by the Secretary
of School Education, whereby the order of court has been complied. A copy of the said order is also furnished to Sri Charlie.
I have supplied.
In view of above development of this court that the present procedure not but continued but and according to this rules. A copy of the order dated 29/5/2020 passed by the department is made part of the report.
32 the contempt file against an interim order. The allegation that interim order that the petitioner were allowed to be continued. Now contempt has been filed that they were not allowed to be continued. But my instruction is that they are continuing in the service lawsuit. The allegation is false lawsuit. This is my instruction.
Continuing.
Lordship, kindly pass the word out timing.
Where is the senior? He's gone or
BT Bora on
he-
next
he's around or he's gone?
around.
Ask whether they are can close this.
But I have received all the certificate from all the head of the institution. So it's 8 to 10.
You are get instruction by now after 5. If he has the information, then it close.
Yes, yes. Otherwise, there's nothing to. My lord. May I please?
Yes.
I filed this application. I
for
striking of the name of the applicant and response number 9 from the purview of this. My
applicant.
applicant.
Your name is to be struck
Yes,
out.
Dr. Rani. Rita Rani. They completed as response number 9 in the state petition.
You are the response number 9 in the
Nine.
writ petition. You said you are not necessarily part.
Not necessary.
My lord, there is a necessary party, and I prefer some time to file an affidavit in reply to their affidavit as well as on objection in the IA. It may come up after vacation.
You haven't filed your objection to the IA.
Yes.
You haven't filed.
No, no.
You will grant time to file objection. Why do you want to come out of the
My lord, my benefit under a career advance scheme, my lord, will not affect benefit if he get it. It is the domain of the selection committee. The issue is domain.
Do you want to
We have no objection.
do you want to contend that even if the writ petition is allowed, it will not affect you?
Cannot affect.
Okay, let him file. Third, Sri A.K. Datta, Senate counsel for the applicant, who is arrayed as respondent number 9 in the connected petition. The applicant submits, according to the applicant, he is not a necessary party. And according, a prayer has been made for striking of her name from the area of party. We see so that senior counsel for opposite party, however, contends that the state response number 9 is a necessary party.
Yes.
And with regard to the prayer made, I come an objection to file. The senior counsel, according to this, grant 3 weeks time to file objection. By way of so, Farah, you are continuing.
I'm continuing, but I was continuing as grade 3. Now they have reverted me to grade 4.
No, I don't.
Then I filed this petition while I did not give up charge. Therefore, status quo was granted. Now, what is there? I am working, but I am receiving pay as per my instruction. I am receiving pay of grade 4.
The REIT is lying, it is the model is given regarding their continuous. So they are continuous as grade 3. So salary part or repetition is pending process.
Grade no. Grade
Let us see the
page 11.
Last time. Till the next returnable date, petitioners shall be allowed to continue in their respective grade 3 posts. And they are continuing lordship.
Farah, so far your demand regarding the will consider that. But this interim order is in respect of the allowing to in
grade 3.
which you are.
But as per my instruction,
No, we are not saying that you have been fairly treated. You may say that you have not been fairly treated. You can file an IA that give us the salaries of grade 3. We are working as grade. We'll
yes,
consider.
that can be done.
We'll consider. We'll close this, but we'll give your liberty. We'll make the observation.
Yes.
But the DP Bora council petition who have filed contempt, alleging non-compliance of an order 22/2020 passed in the connected WP 914 of 2020 by the said order, while notice in the interim it was direct that the petitioners would be allowed to continue their respective dates for Sapera. The SMPC and the Council for Response has submitted that the interim order is complied, has been complied, and the petitioners are allowed to
Indicate.
in with report. And it is connected from here on based on record
Certificate from head of the
the
institution of the
written
twin.
instruction as well as relevant Sri Bora in his reply has however submitted that though it is a fact that the petitioners are being allowed to work as this, their paid salaries of this to to the afforded respect may be relevant for the purpose of adjudication of the litigation or for which a separate IA be filed, the same may not be the purpose of present contemplation, which part only are direct for continuance as with which admitted the petitioner are being allowed. Paragraph 3 of the above, the contemplation stands rules, however, referred to the petitioner to raise the can we
Yes,
retain this?
yes.
Copies of the that based on based report by the learned partner.
I could not come in 32, I'm sorry. No, 32, this matter.
Sure, here.
They were supposed to include that director of pension last by the last order was making. I think it is platform maybe taken out the next week.
We'll have it.
Yes, yes.
Will not say
Yes,
because
yes.
of none has appeared for however this court has said some connection with the cause. However, Madam, you are also appealing as well as the leaders for are present. For 30. And
This was the matter about Article 23, your lordship, the asset and liability statements were given. Your lordship asked me to obtain some instructions.
We have almost finished it.
Yes, yes. But Lordship, I have one little submission regarding that.
That is why it have time. On Tuesday,
Tuesday, but after vacation, matter.
after vacation, we'll forget it. We don't mind, but matter of 24,
13.
Huh? 26.
13.
Huh?
13.
13.
Tuesday.
Lordship, not on Tuesday, some difficulty on Tuesday, Lordship. Thursday maybe. Monday also not an issue, Lordship.
Monday.
Monday.
Lordship, one other request, Lordship, always since your Lordship already heard it. Maybe can we make part or extensive? Last order was that your Lordship has heard it extensive.
This for get Monday.
No, not.
Monday.
No, sir.
Lordship, this matter related to non-provincialization, but as of date, we're having some difficulty with regard to getting communication from the petitioner. Allow some time to get updated.
15 matter.
Yes,
Yes,
Lordship.
Education department, tutors. I think second.
It is second. This is under the 2011 Act, Lordship. That Act has already been gone, Lordship. So nothing remains, Lordship. Now he has to be considered under the 2017 Act.
What is your name?
NJ Chaudhary.
That you're to here we
Yes, yeah.
heard of ARP. Also heard the district petition which was filed here is in connection with the what was the name of the act?
The Assam Vensar Madrasa Education Institution.
Assam
Vensar
Madrasa Institution.
Provincialization Services Act 2011.
Provincial Services Act 2011, which has long been repealed. The current council for the petition has also put that there is no contact decline that just above developed this put the district stands through as there appears right. So you are sitting for long. Sorry. Yes. Can you take us for hearing?
Hello,
Now, what is the matter?
Melody, this is regarding the selection list, Melody. During the selection, I was not my
List of which year?
Law 2005.
2005.
2005, but the appointment were made in 2014.
Original selection process started on 2005.
Only,
published
only
on-
Melody, on last occasion, Melody, the Land Council was asked to take instruction regarding whether any vacancy is
Yes,
there in respect of the that selection.
No, I have received the instruction, no vacancy left, Lordship, I have received that.
Close this.
Lordship.
Heard the details and council for the petition. Also heard.
There is one thing, Malada. On that day, Malada, I submitted before this court. Malada, the court agreed on that day to pay to compensate me, my lord,
because of the consideration of my.
How can we
eligibility.
compensate you? We have to, we'll give you liberty.
Court had given option, my lord. If there is vacancy, then
We'll give you
they
option
are-
to approach the civil court for compensation.
Yes.
Which was done from the petition. Also heard MS RP Bora, Senate Standing Council, as well as SM Senate Standing Council,
Elementary.
Elementary Education. The matter pertains a recruitment process held in the year 2005 with the allegation that in spite of the fact that no select list was published till 2000, there were some appointments made from this this court on the last occasion had directed the learned Senate Council to explore as to whether there is any vacancy of the recruitment of the year 2000. MS Bora, Learned Senate Council,
2005.
2005. MS Bora, the Learned Council. Learned Senate Council, however, has informed that there are no vacancies in any event common. A selection of the year 2005 cannot.
Well, advertisement is of 2005, but selection was made in 2014.
Selection
Due to pen
made in the year culminating in the year 2014 cannot be put after a gap of time. Though the petitioner may not be at fault as he had approved this put the year 2000 for all practical no fruitful no effective limit can put by this court in terms of ordering direct any employment. View of the above, the petition, however, given liberty to approve the appropriate forum for a claim of completion if at all entitled. Yes.
Lordship, matter may be come up after vacation.
No, Lordship, what has been. Lordship, this petition was for promotion. Now, her grievances, Lordship, may see the prayer. Her grievances was for consideration of promotion. Lordship, may see the last order to immediately initiate promotional process that is already initiated. We have given the instruction that is a part of the record. Therefore, technically, this prayer has been met if because ultimately they have a right for consideration.
Okay, we'll have it on Monday. Let us finish.
Yes.
Yes, President. On.
Yes.
We'll have it on Monday, madam.
Yes.
Your name?
Jay Singh Ko.
Jay Singh. Ms. Jay Singh for hearing on instruction of Ambassador. Praise for some. DP Bora. Council principal of who approved college has however that the path of the petition which was judged not has already been addressed as a process for consideration was already and this was also advised to the court. The last of I produced comment date 25/9/2020. Therefore, but so hard as the sending on hired see that as on Monday night. When would consider us fine. Called up. Whereas
For SSN.
whereas we chose that then concept as SSN. Whereas the SM whereas concept of the
Quite limited.
limited, and then you're also there. He does it. Report. Had this put the last one had record non-apparent and also observed that even the persistent non-apparent adverse or can expect get you have the as dispute due to quantum process.
Some other day.
Yes. Your Lordship, due to some personal difficulties, my senior has to leave
Some other
early.
day.
Which are the
40, 44 to 47.
on a prayer made of adjourn after vacation.
After
Yes, Your
Visibility of full matter.
Yes. Some are all, some are 19 meters. Some tech meters are
Immediate
immediate after.